All right, welcome back to another episode of Girl, Is That Legal? With your host, Attorney Simone Redwine. So thank you guys for coming back. Guys, I'm excited about this one today. We got some stuff to talk about. So one of the main things that we're going to get into is yesterday, Judge Christina Peterson went on the Big Tigger morning show. We're going to look at her interview, and then we're going to compare it to what we saw on the police body cam, because I couldn't believe this one. And then we're also going to talk about the ruling from the Georgia Supreme Court that removed her as judge. And I want to be clear, she has only been removed as a judge, and that's only for the next 7 years. She can run again after 7 years, and if elected, she can take a bench. That's in Douglas County or anywhere else that wants to elect her. But it has not in any way at this point impacted her ability to practice law. But I want to ask you guys, after we watch this interview, I want your thoughts on whether you feel like this interview is helping or potentially hurting her. But before we get into that, I'm going to let people go ahead and come join the chat. And I saw a few stories on social media we're going to cover real quick as people are joining in. I know for some people it's their lunch break and other things. But so here we go. Let's get this share going. So a few people have sent me articles about this topic. So here we go. What I'm referring to is there are a lot of different bloggers that have been talking about the fact that Diddy allegedly married his fourth baby mama, Dana Tran. Specifically on the blog on Instagram, The Girls, which stands for The Girls Spy In, it states, according to Media Takeout, and y'all, Media Takeout used to really be the source, like in the early 2000s. But then they got to be like so outlandish to where they didn't seem to care anything about accuracy as long as they were able to discuss, get something salacious. So they kind of lost their luster. But regardless, Media Takeout states that Diddy secretly married baby mama number 4, Dana Tran. According to a top source close to the billionaire, Diddy and his fourth baby mama were married in Hawaii over the weekend in a private ceremony. The insider told us that Diddy flew Dana and their daughter to Hawaii to celebrate her birthday, and that while there, Diddy surprised her with an impromptu wedding ceremony. Dana's birthday is today, and it's unclear whether the newlyweds are still in Hawaii or have returned to Los Angeles. The insider was not, however, able to confirm to Media Takeout whether the marriage ceremony was legal or spiritual. Now, many people have been discussing this because the thought process, and a number of bloggers have came out and said that their belief is that the thought process is that he married her so that she could not testify against him. In addition, Dana Tran works in cybersecurity. So it is believed that Diddy had Dana Tran hack Kim Porter's computers and or her security cameras, but Kim Porter's stuff, so that he could spy on Kim Porter. And that as a result, that is why Diddy wants to marry her so that they could invoke this spousal privilege. All of these claims are alleged, but when I tell you some of these bloggers are running with it, y'all, you're going to get the tea here. You're going to get the law. And when I don't know, I'm going to tell you that I don't know. When I'm basing certain things based on my years of practice, I'm going to tell you that. Here's why that theory is probably incorrect and doesn't totally make sense. It's juicy. And baby, I love a good legal conspiracy theory. Now, what I'm going to explain is how spousal privilege law works and why it's not going to get the result. If that's the result he was thinking he'd get, it ain't going to get it. So how spousal privilege works is the concept is that the sanctity of marriage is so special that if a husband tells a wife something, the courts should not intervene and force one spouse to testify against the other. This privilege is so important, so sacrosanct, or so important that either of the two spouses can invoke it. In other words, that would mean if this were true, okay, hypothetically, as an example, it would mean that Even if Dana Tran wanted to testify, Diddy could invoke the privilege to prevent her from being able to testify. She just simply couldn't, even if she wanted to. Here's the problem here. That privilege only applies to communications made amongst two people during the marriage. Doesn't apply to communications you had prior to being married and then you marry somebody. Because those communications have nothing to do with the sanctity of marriage or protecting that privilege, okay? It only goes from literally the date that you were married and thereafter. Secondly, it does not apply to co-conspirators. Come on now. How many different times have we seen different crime shows where a husband and wife, like maybe the wife will be given a deal that says, hey, if you testify against your husband, you're going to get a lower sentence. It happens all the time. That's because this privilege could not be invoked for co-conspirators. Therefore, here, even if Diddy did this, it's not going to get the result that he wants, because if in fact Diddy had Dana use her cybersecurity experience to hack any of Kim's stuff, they would then be co-conspirators, and therefore the privilege would not exist, even if they were married at the time of the hacking, etc. They weren't. So that's another reason why it won't apply, is because those acts and those conversations took place prior to the marriage. So the next time you see a chat and people are going in on that, you could be like, my legal bestie said that's not going to work because of this. But also, just because it's not going to work doesn't mean he didn't actually do this. I say that because many people will do things like this thinking that it will work. I mean, they do certain legal maneuvers thinking that it's going to work. And it's not until after they do the maneuver that they realize it was a waste of their time. Heck, let's look at Tasha K filing for bankruptcy. She wholeheartedly believed that by filing for bankruptcy, she would be able to not have to pay Cardi B's judgment. In fact, I firmly believe that's why she didn't take the original court case very seriously, because she was able to garner millions more followers. She literally went from 200,000 followers when the whole controversy started to over 1 million that she has now. And in doing that calculation of the marketing, of the sponsorship and so much more, she probably thought, hey, well, if I can grow substantially from the publicity this case is going to get me, I'll simply take that and file for bankruptcy. Little did she know that the law says where a court awards punitive damages, and that's part of the money that was received here. Punitive damages, the best way I describe it when I try to teach my students is I use the hood hypothetical. Punitive damages would be like when your granny tells you quit running around the house because you're going to break some of her fancy stuff, and you and your cousins keep running around, and then one of y'all breaks, let's say her good lamp or her good china, she lines y'all all up with a switch, and then she whoops each one of you in front of the other. Punitive damages are when you whoop somebody in front of everybody else so that people know, don't you do that again. Punitive damages are an extreme punishment that you give someone to make an example out of them in a situation where their behavior was intentional and malicious or egregious, which is what Tasha K did. So the end result is, my point is simply here that people all the time do legal maneuvers thinking they will be successful, and they're not. All right. Somebody said, did he try and bail out Keith D? I don't know if Diddy try to bail that guy out. Last night, I was actually watching a little bit of the court session that was between WAC 100, who put up the bail for the guy who's accused of killing Tupac. That was interesting. I'll get into that another day. But that was this one. The second case that I found, hold on, that was interesting. And then we're going to get into Christina. I just want to give everybody a chance to kind of hop on in. So Hollywood Unlocked posted this. The title is Transgender Woman Assaulted by Male Cellmate Wins a Judgment Against the United States for Failing to Protect Her while she was incarcerated at the Tucson Federal Prison Men's Unit. Effectively, so this was someone born a man who was trying to transition into a woman. They still had their parts now. And I have to tell you, that's one of the things that confuses me. When all this transgender stuff was first introduced, I always assumed it was a full and complete transition. I really think it's confusing. I think they need two different words. I think they need a word for people that switch their body parts, and then a word for people that got a little of this, a little of that, little top and little bottom, like a mixeroo, just so you know what you're dealing with. Like maybe call one transgender and the one called like transgender pending. I don't know what you would call it. But here, basically, because the person still had all the male parts, they go to a male prison. Seems reasonable to me. Now, in some states like New Jersey, if you identify as the other, you're allowed, or at least they had been, putting you in the women's prison with your Peter Weeder, which I find utterly ridiculous and unsafe to the public, but nobody asked me. However, here with this case, what's interesting is basically it says a transgender woman who was assaulted by her male cellmate has won a judgment against the U.S., which failed to protect her while she was incarcerated. The lady calls herself Grace Pinson. 38-year-old Grace was listed as Jeremy Pinson in court documents. And here's the interesting thing. Grace represented herself. She represented herself and won in a 4-day bench trial. That means a trial to the judge. Now, if you're going to represent yourself, which I never recommend, I think that it is good to do it in a bench trial. Bench trial means to the judge, not a jury. And that's because I believe that judges will inherently give you a little more leeway when they know you're self-represented versus if you're in front of a jury. Anyhow, it says in court documents, the transgender woman claimed that her male cellmate attempted to R her in July of 2019 and then allegedly beat her with a closed fist for several minutes. Following the attack, she was taken to a hospital for treatment of nasal bone fractures. However, before the incident, this woman was sentenced to 20 years in federal prison in 2007 after being accused and convicted of writing threatening letters to politicians and federal judges in Oklahoma. Now, I'm very curious of this person's race because 20 years seems like a really long time for writing some letters that are threatening. I understand, yes, it's illegal, but dang, 20 years. I mean, they didn't even, it was whatever. All right. It says Pinson claimed that she was transferred from the Minnesota prison to the high security penitentiary in Tucson after filing a lawsuit seeking gender affirming surgery. After the incident, Pinson filed a civil rights suit against the U.S., claiming officials did not protect her while housed inside the men's unit of the federal prison. She was seeking nearly $300,000 in damages, and after the 4-day trial, she was awarded $10,000. She got $10,000 for her physical injuries, her pain and her suffering, and her emotional distress arising from her physical injuries. So basically, she got nothing. She got nothing. This case been going on for 5 years. She got $10,000. That's nothing. And then it states, in the ruling, the judge found that the prison staff did not know beforehand of the incident that Pinson's cellmate had already been threatening her. Okay, so if you didn't know about it, you're not given the heightened level to protect her. It says, however, the judge did agree that the penitentiary was negligent in ensuring that the transgender woman's cell had a functioning duress alarm. That's basically, the alarm that you push if something like this is happening. So her alarm wasn't functioning. And that's the alarm that's used to alert guards or other prison staff to emergencies. So somebody says, so basically 2 men were fighting and he lost. Somewhat. But the gist of it is, so a lot of people were upset, feeling like she shouldn't get paid for effectively being transgender and being upset that she's put in a male prison. But to be clear, that's not what it was. She only got $10,000 after the course of 5 years after being beaten and da-da-da-da-da. And that was simply because they do have a duty to have a functioning duress alarm in every cell. This is the same type of alarm, by the way, the Judge Christina hit when she was mad that the bailiff took too long to escort her to her courtroom. But yeah, that type of alarm they're supposed to have. So here we go. All right, now back to Miss Thing. So here we go. I'm going to start for you guys. We're going to take a look at we're going to take a listen to the interview she did the other day on Big Tigger's morning show. Now, here we go. Lord have mercy, y'all. And on that one, here we go. And on this one, she basically is going to give her account. And I got it. Let me make sure I got it on. I want the playback speed. We're going to do, I'll start it on 1.25. If it sounds crazy, we'll just adjust it. Here we go. All right.
She's the first African-American and woman judge who was initially elected to the bench by the people as opposed to being first appointed. My first question, after reading all these headlines, are you still Judge Christina Peterson?
Well, I will always be judge, but no, I'm no longer serving as of yesterday from a Supreme Court decision.
Okay, this decision.
Once you're a judge, you're considered a judge for life. Technically, I'm Judge Redwine because I was a judge.
Says you.
Oh, I should add that, considering, Cherie, what's her name? She by Cherie wants to be called Dr. Whitfield. Now, Black China did want to be Dr. Angela for a while, and everybody else who gets their honorary doctorate wants you to call, what's that cutie pie? V, she wants to be Dr. Excel. So I guess I should be, go ahead, call me Judge Redwine.
You acted in willful judicial misconduct. And that stemmed from 50 ethics charges?
Well, if you have just started following, it's kind of a long story. But basically, when I was elected, there were certain subsets of the county that didn't want me to be serving Douglas County. Of course, I was a history maker. I was the first female, first Black, first Democrat, because we're still partisan in that race. So ever since I was elected, people started filing charges, frivolous complaints against me, baseless complaints. But the JQC was weaponized, honestly, in my opinion, against me and pursued these charges. So ultimately, they came up with 50. If we break down the 50, you would be thinking, why are we here? But in essence, we went to trial on the 50. They dismissed 20. They don't talk about that. They dismissed 20 before we even got to trial. Okay. When we went to trial, the hearing panel got rid of another 10, so 20 was left. And 20 stemmed from 5 incidents that had really, if you want to be honest, nothing I could control. Okay. So
wait a minute.
They ran it in the media. They tried.
Hold on. She just said there were 5 incidents with nothing that she can control. Now, we know if you watch the prior segments I did on her, one of those 5 incidents, well, let's talk about 2 of them. One of them is her hitting the panic alarm, which shut down the courthouse because she was upset that a bailiff was taking too long to escort her to the courtroom. Meanwhile, there are ways that you can walk like behind the scenes to get where you need. Another was that she held a wedding after hours with no security present, which puts the entire courthouse in jeopardy because someone could be hiding in the bathroom. Someone could place a weapon there and then come back the next business day and use that to hurt someone in the courthouse. But she did that to host a wedding for one of her homegirls. And then thirdly, and for me, one of the most egregious was when she actually locked a woman up who was simply trying to correct the name on her marriage certificate. She sentenced her to 20 days and held her in contempt. She had complete control over that, and she never likes discussing that. And to date, I haven't seen an interview where she explained herself.
Me in a court of public opinion instead of really looking at and seeing if I did anything. Nothing I have done has been willful.
Right. So what were they saying that you violated? Like which conduct?
Well, for starters, if you look and at these charges, all of them were pretty much run by one station. It was Fox 5 and it was a Randy Travis.
Oh.
Okay. And all of those were leaning articles. And basically one charge was they said I did a courthouse wedding where I violated courthouse security. But when we went to trial, you saw that I didn't let those people in the courthouse. That was the sheriff's deputy that did that. So if you see on the video, it was 15 people coming in the courthouse. That wasn't Judge Peterson. That was the sheriff's deputy conducting his own African wedding and letting 15 people in. They just manipulated the video and made it look like I was doing it.
Okay.
Yeah, I was there, but I had a wedding. I had a Hispanic couple, a couple and their 2 kids, and I was going to do mine outside. But then I called the sheriff and I said, "Hey, your people are here. They're doing weddings." He was like, "Well, my pastor deputy is there. You go on inside, you find the security." So I went inside and did my wedding because his deputy was there doing his, and he had the door open. Never mind that. They said, "Well, we get to trial," and the sheriff was like, "I don't believe I said that. I don't know." Trying to play.
Okay, so she's saying here. Now, she doesn't discuss the fact that initially they claimed that they told her no because it's after hours. Specifically, what they said was there wasn't a deputy available to do security. So what she's saying is, yeah, there was one because he was there and he had some people that were there. So those are new facts. Here we go.
They'll play the game. And in essence, the panel stated they believed the sheriff when he said, "I don't think I said that. I don't think I said that."
Oh, wow.
So then, but the evidence came out that we don't have a policy. There was not a courthouse security protocol.
So how did you get in trouble for it?
Because it's me.
Oh.
You have to understand.
Well, why would you? I don't understand why you would. If a courthouse has metal detectors, I don't know why you would want anybody coming through without being checked through the metal detectors. And in order to have that done, you have to have deputies. Anyway, hit that like button, guys. Hit that like button. Hit that subscribe if you haven't already. Keep going. So what we're listening to is this is Judge Christina telling her side of the story and her thoughts yesterday on Big Tigger Morning Show. We're breaking down her version of what happened and how she feels that she's been unjustly treated.
Understand what this is.
So-
That is because it's me.
When the panel says they identified 28 proven counts of misconduct out of 30 alleged violations, as me reading that seems like they said you definitely did 28 of the 30.
And that is something. So I don't know. Y'all haven't really been following the trial and the I don't know if you've been following. The trial was actually published on YouTube.
Okay.
So all of it's on YouTube. There's other charges such as there was a case where a woman thought I didn't sign an order in time. It had been 60 days. Keep in mind that I'm still waiting on judges to sign orders in cases that I filed 10 months later.
Oh, wow.
So I'm getting charged with not signing an order in 60 days. And then there was an issue where when they came into my court, I have clerks. So most judges are just judges. The probate court, you have to supervise the whole staff. You have to train them. And I had to take on that coming into this office because the prior judge was not an attorney.
Mm-hmm.
He was a judge. He didn't have court anything. So when I came in, I had to teach everybody everything.
That's true.
And so they were doing the practice of backdating. If I sign an order on the 18th, they would backdate it. If they got it, they would backdate it to the 18th, which is improper. And I didn't know they were doing that until the JQC filed that complaint. Well, my staff, when they were testifying and they were deposed by the JQC, told the JQC, Judge Peterson didn't teach us that. The prior judge did. Oh, well, Judge Peterson should have known y'all were doing it, so we're going to charge her.
So basically you are the manager of that staff. So even though you didn't know, they still held you responsible.
Right.
But even though you had all these different violations, you were still
listening.
allowed to sit on the bench.
Right, but keep in mind, if you had that same energy with holding me to the standard of perfection and making sure when I come in the door, I know everything and I know all the practices. If you had that same energy with the prior judge, I wouldn't have to come in here and correct anything. You understand? So that's kind of where we're at.
Christina Peterson is in the building this morning with the Big Tigger Morning Show on V103.
No, hold on. No, part of what happens too, part of the challenge is that the JQC, which is like the judicial whatever committee, it's the judicial ethics committee. They don't know to look into something unless someone files a complaint. So it may have been that prior person could very likely have been doing things he wasn't supposed to either. It's just that no one filed a complaint against him. And she had been doing certain things that were irking people. And I think that may have been what triggered. And to let people know, anyone can file a complaint against the judge. You do not have to be a lawyer. You do not have to be, and anyone can file a complaint against a lawyer. You don't even have to be their client. Generally, it's clients or people that are directly impacted, but anyone could do. So if you saw a judge, like if you saw an attorney doing something like racist, you could file one against them if you wanted to.
You can't imagine
Which
yesterday.
I don't encourage, but.
It was all right.
I mean,
I'm still blessed.
you were
Right, you still
removed
pushing
as a judge after being elected. So what was your morning like this morning? Like, what were your thoughts?
Honestly, I was in expectation of it. Yes, I was. I was in anticipation of it. I have been attacked since I've been in office, and these attacks are not like if I could tell you what's going on, you would think it was. I mean, people talk about different Illuminati and stuff. This guard in Douglas County is a whole different beast.
And you were elected what 2020, right?
2020, and I started in 2021. So since I started in 2021, I mean, I've had to endure a lot of things. I'm talking about attacks. I'm talking about lies. I'm talking about groups of people getting together and conspiring against you. I'm talking about they're using their news media to put out lies about you and to ruin your reputation. I'm talking about driving down the street with my foster baby in the car and my car catches on fire. I'm talking about real things.
Who ever did all that?
I'm talking about real attacks. They don't want, you're not welcome.
Oh gosh. So she's saying she thinks that someone set her car on fire. That would be horrible. And mind you, she's a probate judge. She's not a criminal judge. She's probate, which means she's over things like marriages and wills and estates and like probating wills, dealing with properties of people that have passed away with or without a will, that kind of thing. She doesn't handle criminal matters. She doesn't handle divorces or family law.
Welcome here. So
Douglas County, is that what you're saying? Okay.
Correct.
For your term to be ending in December and them to still proceed with the fervor that they did to get you removed with only really 6 months to go, what did that say to you?
It said to me that they were overzealous about their focus and their intentions. I say they did what they needed to do. I think they're really pushing for the lady that ran against me. They're really pushing for her to be in office, and they were really upset at how I was exposing the things that she has done. So she's not even qualified to be running for that office. She hasn't had the requisite, she hadn't lived in Douglas County for the 2 years required for her to live there. I have presented that information to the governor, to the Secretary of State. I presented that information to the Attorney General. And basically, if you look at her documents and what she's done, she could possibly be charged with felonies. So therefore, or, oh, you're exposing what we want, so let's try to see if we can get something on you. So
you think this is pretty much a vendetta out on you? Do you think that?
of course.
Mm.
Gotta
Now, I do believe that she probably ticked some people off by asking for a she got a $36,000 pay increase over the prior person that had that role. But her request for that seemed reasonable as an attorney because the prior person was not. So the prior person, he was paid $110 for the same position. He was paid $88, and then what happens is you also get fees. Here, she asked for an extra $36,000 plus all of the fees. So that brought her salary up to like $144 plus the fees, potentially would take her salary over to $280. And so I do believe that there were probably a plethora of people in that county who thought, okay, that's ridiculous. And they probably, the moment you do something like that, they very well probably put someone up to run against you. So I do believe that that's probably very accurate, that they wanted someone to run against her to beat her simply because someone else in office could save the county about $130,000 per year. But that is because they stated that her salary was greedy. Other counties capped fees. Douglas County did not. So whereas Fulton County, it said Gwinnett County caps the fees at like $7,500. Fulton County caps fees at $15,000. Douglasville County, where she presided, did not, and that's why she can make an additional approximately $130,000 or so. All right, hit that like button, hit that subscribe if you haven't already. Queen of Everything, thanks for joining us. I see I have a new member. Thank you, Love and Skill. Thank you so much for joining us. All right, so this is Judge Christina speaking on the Big Tigger Morning Show yesterday. She's going to talk about her arrest. She's talking about being removed and how she feels and what's next for her. This is her right now. She's speaking on some of the accusations against her in the ethics complaint. It's important to note that ethics complaint had nothing to do with her arrest. Everything with the removal of her being the judge, that all pertained to things that she dealt with prior.
Gotta know. Yeah, and I just wish, and that's, I just wish everybody understood what went on behind closed doors in these politics, the political world, because what you see out there is not the story. I have always been a woman of character, always been a high-performing woman with no issues until I got into this political realm. So I just hope you take a moment to try to understand what's really going on.
Former Douglas County Judge Christina Peterson is sitting with us this morning. When we come back, we'll talk about this viral moment.
And a pimp named Nasty Nesta. What a name. Okay. All right, pimp. Thanks for joining us. Said, it sounds like they were mad that she had the qualifications to play them at her own game and someone was salty. I absolutely believe that they were salty about her salary. I think that probably created a bad taste in their mouth initially. And they probably were to some extent like, okay, this ain't gonna work. We don't want to have to deal with another 4-year term of her. But when you know stuff like that happens, you have to in turn show them why you're worth the money that they're paying you. Show them why they made a great decision with hiring you. And you do have to be aware for little nitpicky things. And the backdating, remember she basically said the backdating, it wasn't her, it was her staff, but that it was taught by the prior administration. The problem is you have to take some form of responsibility, even if your form of responsibility is saying, I didn't do what the other person did, but I'm retraining everyone. But you'll hear her, I'll let her continue. Here we go.
When we come back, we'll talk about this viral moment. Hear why she says it was all a setup. When we come back next on Be With Her. Sitting with us this morning, former Douglas County Judge Christina Peterson, who was removed.
Now, if you haven't watched and seen the fight, in the prior 2 videos, I showed the first video, I showed footage. The second video, I show extended footage, plus new footage of the fight. Inclusive in that fight, you can see that gentleman swinging on that woman. You do also see her squaring up with him, taking off her heels, and swinging on him. But either way, I don't think anyone disputes that man certainly used excessive force as it relates to a woman. And that force did not at all seem necessary. It's one thing if you grab her arm, spin her around, throw it to the ground, but it definitely did not seem necessary to control that situation. Someone says, now all those incidents, Pimp says, now all those incidents she had in her past made me question why she put herself in that clubbing incident in the first place. I would have had my people come to my house for a party. Here's the thing, it wasn't even a party, it was her friend's party. So agreed. Yeah, you got to be more careful, especially when you've already had a hearing. So what happened was she had previously, before the fight incident, had a hearing where in that hearing, it wasn't the Georgia Supreme Court, but it was the committee had ruled that she should be removed. So then she appealed that. It went to the Georgia Supreme Court and it happened to be pending. Baby, if you know you have a pending appeal for something like that, you need to be on your best behavior. Even if you know that they're not able to consider that new event, it still is in the back of people's minds.
Moved from the bench yesterday by the Georgia Supreme Court. A lot of people seem to think the incident at Red Martini was the final nail in the coffin. An Atlanta police arresting officer accused Peterson of punching him. A statement from the department accuses her of pushing the officer twice. Peterson faces battery on an officer and felony obstruction of law enforcement charges. Her attorney, Marvin Arrington, who is representing her, maintains that this was a misunderstanding. She was breaking up a fight, believes the case will be dismissed. The body cam and cell phone footage was released and gone viral since. After we listen to this, I want you to tell me what we don't see in the video.
No, he can punch me. Everything for no reason. Let him go. Let him go.
What are we missing?
You're missing what happened before that. You're missing the attack on the woman. That's what you're missing.
So what I saw.
She continues to talk about the attack on the woman. That has nothing to do with her conduct regarding the police. There is no body of facts that says, okay, assuming that this man absolutely was attacking this woman and she was there to break it up, it still does not allow her to hit a cop, to push a cop, to decide that she doesn't like the way that security is even handled. Even if it was just a security car, take the police out of it. She does not have the authority to come in and even shove a security guard if she decides that she doesn't like the way it's being handled. Now, you're going to hear her reference defense of others. I'll let her speak and then we'll go from there.
What I saw in the video, the woman is screaming, hey, he hit me. And you're saying, let her go, right? In the video.
Correct. And the guy that I was talking to was not an officer. I was talking to the guy that was holding her. Whoever that was, I don't know if he was security or whatever. He didn't have authority to be putting his hands on her. She has already been attacked. I don't know if he's part of this attack. I just know I have a right to defend third parties. I know she was a victim and I know you needed to get your hands off of her.
Did you know her?
No, I don't know anybody.
You didn't know her at all?
I didn't know her.
Okay. If you don't know her, how do you know all of these things you just articulated? How do you know this man doesn't have a right to touch her? He does. He's security. Security's job is literally to secure the premises. He had on a security shirt. So even if she uses the argument, she didn't know that the police was a policeman, even though he's fully in uniform. If you're saying, I don't know this person, I've never met this person, what gives you the right to decide that security is not entitled to secure the premises, especially if your point, remember her point was she was trying to bring the woman from the fight area to safety. Well, that's exactly what security did. So here you go. Somebody said, I'm a little behind on the live, but this has such a despicable victim mentality. She's already deemed unfit, bringing shame upon herself. She has. So here's where we are in the live. In the live, we're listening to her give her account of the fight and what happened and why she feels that her case should be dismissed. Now, a pimp says, so does this mean that basically only she can do her duties as a lawyer in the state until Georgia, either her suspension ends or she decides to run for judge, and if they choose to let her back in? Okay, so she's no longer on the she's no longer on the bench. What happens is the governor actually, which sucks because he's Republican, the governor gets to appoint a replacement for her to serve out the rest of her term, which is going to end December 31st. The governor was smart, which he's not. He would appoint the person that already won. That way that person can get accustomed to it. And it's less of a waste of county resources because it's better to have the person who's going to be taking over that position January 1 to be able to get in there, train their staff, get used to it. But that's a different story. Somebody says, has this woman ever assumed accountability for any of her actions? We about to see about that now. So here, I'm going to roll it back just a few seconds so you can hear her statement. But she's referring to the fight now.
What are we missing?
You're missing what happened before that. You're missing the attack on the woman. That's what you're missing.
So what I saw in the video, the woman is screaming, hey, he hit me. And you're saying, let her go, right? In the video.
Correct. And the guy that I was talking to was not an officer. I was talking to the guy that was holding her. Whoever that was, I don't know if he was security or whatever. He didn't have authority to be putting his hands on her. She has already been attacked. I don't know if he's part of this attack. I just know I have a right to defend third parties. I know she was a victim, and I know you needed to get your hands off of her.
Did you know her?
No, I don't.
Girl, you sound stupid. If you said you don't know who he is, how do you know he did not have the authority to be separating her from the man who's allegedly beating her? This literally sounds stupid. And I can't believe she said it out loud. Sorry, I'm working on not using the S words. You guys in the chat have been really helping me. Here we go.
Oh, I don't know.
You didn't know her at all?
I didn't know her. I just saw her getting attacked. And I mean, how that man was punching her, it was like he was in a boxing ring.
Were you the only one standing?
Now, the one that's holding her is not the person that was punching her. Remember, the person that she's referring to that was holding her was actually the security guard.
For her?
Yes. And I just didn't listen. I was minding my business. And let's be clear. I just don't go to that place. I have a friend who, it was his birthday. I love this friend. He's a very kind guy. And I said, okay, I'm gonna go. And it was a night that was fine. And then we were just waiting in line to get some hot dogs, some stuff we don't need at 2 a.m. or whatever. So I just know that I just was sitting there, and then all of a sudden, I'm shifting on my feet because my feet hurt, and then I just saw these. They just come past me, and just the man just started hitting it, and I'm like, I'm shocked at this point, like I'm like triggered, like what in the world, like I don't know if it just really did something. So I knew I didn't have any might to stop him. I can't punch him. I can't do anything, but I could try. He was pursuing her, so I tried to pull his shirt and just get him off of her.
So was
nothing wrong with that?
Okay, so they said the allegations are you put your hands on an officer, right? So that's what they're saying. But you're saying you didn't see him in officer.
Okay, no, hold on.
Uniform?
That's two different things. So basically, you're talking about. So there was an attack, and then there was when I was trying to get her out of the man's grasp.
Gotcha. Okay.
At that point, the man's grasp is when they're trying to allege that I hit an officer.
Okay. So when you were trying to
lies. I mean, you know what? I'm so these lies piss me off so much. Okay, we're gonna show the video. We gonna go to the video. Hold on. Didn't his shirt say security on it? Yes, that's what I'm talking about. They're two different men. There's a big guy in a black shirt. Okay, that swung on the girl. Then there's security. These are two totally different people. Actually, let me show you the video. If she probably blocked me. Yeah, she probably blocked me, so I can't show you that video. Let me see. Oh, actually, you know what? It should still be here. Hold on. Let's see if I got it. Some additional footage that she had. Where did I? Here we go. What are we on? Here we go. I'm sure she blocked me. I have to go into my fake account. Hold on. Oh, official. Yeah, I'm locked. I think it's official, Christina. Yeah. Oh. Let's see. Bam. Okay, yep, she blocked me. I can't pull it up from here. But there's a second video of another angle. I could have sworn that I had downloaded it. Let me check one more time. Hold on. Let me check. That I had. It's somewhere here. Hold on a second. Oh, hold on. Let me see. All right, let's see if I can get that. I can't. All right, what I can show you is what you'll see is, here we go. I'll play it from Law and Crime. Somebody said, I have secondhand embarrassment for her. Appeal says take the L, recalibrate, and rebrand. She must calculate her powers of authority and persuasion on this situation. All right, so here we go. This was the knew that block was coming. It's fine. I earned it. All right, here we go. We're gonna share this one. All right. The arrest. I'm gonna roll it back just a little more. All right, what we want to see is I want you to see how at the time where she starts to control the police and the security guard, she's not at all interacting with the guy who hit the woman. See, here we go. She's screaming, let her go, let her effing go. That's leave.
And that's on me.
Here we go. Let me roll it back one more time so we can see it again. And actually, I'm going to slow it down a little bit.
The last person that ever tried me like this died 30 days later. I pray for you. Lawless wise, where I be in here with Young Thug. I am Woody.
Yeah.
Where in the world is this man going?
Yes, once he entered the fight when it was under control. That's exactly the
Don't
point.
touch me. You a lie. You're a liar.
But the thing is, because she continues to feel like she's above authority. So here we go. All right, this is Christina. This is when she entered the fight. This is the officer is taking the left hand of the woman, and this guy to the right is actually the security guard. So Christina's facing the security guard, telling the security guard to let her go. Yet she says, I didn't know who this man was. So, and the police officer.
Let him go. Let him.
Yeah, there we go. There we go. All right, so let's go back to her description. Here we go. Let's continue to hear her description of what happened.
Tell them to let her go. An officer actually grabbed you and told.
Let's roll that back just a second.
You're talking about, so there was an attack, and then there was when I was trying to get her out of the man's grasp.
Gotcha. Okay.
At that point in the man's grasp is when they're trying to allege that I hit an officer.
Okay. So when you were trying to tell them to let her go, an officer actually grabbed you and told you to get away from the situation, and that's when
The officer said nothing to me.
He said nothing.
Hit me to the ground.
He what?
He knocked me. He knocked me out. He didn't say anything to me. He didn't give me any commands. He didn't say he was an officer. So, but we'll talk about. I can't really speak much about that. But I'm just saying.
He's right. He did not say he was an officer. Other people said he's a cop. He's a cop, and that says to me, she was doing something to him that you shouldn't do to a cop. That's what makes me think she probably pushed him. I don't think she punched him. I did not see a closed fist on the video. But there would be no reason for people to say he's a cop if she wasn't doing something that is impermissible to do to a cop. And what's impermissible? To push them, to shove them, to hurt them in some capacity. There we go.
Lady, and you see me get knocked out.
And again, if she didn't know that that's who he was, then that's a different discussion. But you'll see here, she continues to say she never did anything.
An officer. That's what you saw.
Okay. Afterwards, there's other videos that have come out. Let's listen to some of the other interactions.
No, take me. And I don't care. You don't need identification. You have locked people up, and you have picked up dead bodies when you don't know who bodies it was, but you picked them up. Take me where you need to take me.
I'm trying to.
No, take me where you need to take me immediately, expeditiously.
And you're preventing
Take me. I could give a damn. Take me where you want to
She
take
wasn't
me.
drunk.
Now. Take me where you want to take me.
Answer the criticism being placed on you that this is not conduct becoming of a judge.
Mm-hmm. Well, I understand that. Again, you're looking at the effects. You're not really understanding the cause. In that instance, if you've been violated, I don't know if you all have been violated by an officer. I don't know how you have been, in my opinion. Honestly, I can't go too much into it, but what I think the officer was doing was trying to cover up his improper acts. He rode around with me for 7 hours. He arrested me at 3:00 and I didn't get to the jail until almost 11.
Wait, so
Okay. That was the first lie where I was like, okay, girl, cut it out. Cut it out. She says, she says the cop was trying to cover his improper acts. I'm curious, what did the cop do improper? Because if your argument is she didn't know he was a cop, which is what her attorney was saying. Her attorney was saying in the video if you go to her page, which is a official Christina J, she reposts a comment from her attorney. I think his name is Marvin something or another, where he's basically saying in the video, you can see she basically the way that she's facing, she can't tell that this is a police officer. Okay. Get your story straight though. Because if it's I didn't know it was a cop, then it should simply be, I'm sorry, my bad. There was a misunderstanding. But now if your statement is I didn't do anything wrong at all, he assaulted me, that's not what this video shows. And mind you, they had a press conference before the video came out, demanding the video came out, and the video came out, and now we have an issue. Somebody said she didn't mention that in the press conference. She didn't. So I'm not clear what the police did that was improper, because if you're grabbing on a police officer, he has every right to handcuff you. I'm not sure what else he's supposed to do. It said, but if they knew he was a cop, I don't understand why she didn't know. That's a good point. If the other people in the crowd are saying he's a cop, it seems like he had a vest on. Yeah, he had a whole uniform on, because he's visible later in the footage. And it seems like he had a vest on and probably had his badge out. He had everything on. So some people are confused because he was doing what's called an official like after hours job. So he wasn't policing, but he was hired as a policeman to provide policing activity for this nightclub. Here we go. Somebody said you can never remember a lie, which is why the facts always change. Here we go.
So, okay, between that time, what were y'all doing? What was he doing?
Oh, this is my favorite part, y'all. This is where she talks. She says police did improper acts, and that it wasn't until it was like 7 hours that the police officer had her in the back of the car. We're going to listen to it. Then we're going to watch some clips of the footage so that we can have a clear understanding of why it was that it took so many hours for her to be in the back of that car.
What honestly, I can't go too much into it, but what I think the officer was doing was trying to cover up his improper acts. He rode around with me for 7 hours. He arrested me at 3 o'clock, and I didn't get to the jail until almost 11.
Wait, so okay, between that time, what were y'all doing? What was he doing?
He was antagonizing me. He was, remember, the
for
cuffs,
7 hours.
Listen, the cuffs were so tight. I had bruises on my arms. I mean, listen, he was stopping his car and getting out, and he was nervous. He was visibly nervous, and he was making phone calls, private phone calls.
Wait a minute. So for several different hours, you're saying 7 hours. So from what time to what time?
3 until after 10. That's when I got to the jail. And I'm going to say that I believe he was trying to cover his tracks. He had violated me, and then when he found out and he knew on scene that I was a judge, because once he put me in cuffs, people were like, "That's a judge." So then I think he had to come up with that whatever story whatever they ran on the news. So it was inappropriate. I asked him I said, "Am I under arrest? If I'm under arrest, I would like an attorney before I give you any other information, because if somebody ever lies on you, you need an attorney. We don't need to even have any more conversation." So that's what I did. I said, I don't want to give you anything. And moreover, I would have my license if you didn't knock me out and my purse got taken.
Okay. We're going to look at the footage. So remember, we're going to look at the footage. Ooh, these are my favorite. Somebody said antagonizing her. She said, no, remember, she says that for 7 hours, she was in the back of the cop car and he was antagonizing her. And she felt like it was a setup, and then he was driving around and he was making calls. And this was all she believes it was part of his cover up, of how he was going to cover up the facts. All right, so here we go. So I want you to pay special attention to the top right corner. It says, when I hit play, it's going to say, it's like she was arrested in the document around 3:18 in the morning. Okay, 3:16 is that. 3:16 is up here on the right corner. 3:16 top right corner, guys. Listen, why is she lying? All the actions are on tape. That's why I'm frightened. Anybody who could bold-face lie like this as an attorney, that's frightening. So we got 3:16. Hold on, I'm gonna fast forward a little bit. I'm actually going to do it level 2. So this is, hold on, I want y'all to be able to hear it. So I'm actually not going to do 2. We're going to do 1.5. Hold on. She literally, so she neglects the part, y'all, where the truth of the matter is the reason she had to be behind the car, she was in the car for 7 hours, is she refused to tell them who she was for 7 hours. She literally refused, including at times she kept saying, Google me. And they said, okay, well, tell me your name so I can Google it. She refused to give her name and then goes on this radio show lying and claiming that the reason she was in the backseat of a car is because it was a setup, because they were, because he had, the police officer was trying to cover his story, etc. Here we go. So we got the arrest. And this arrest is long, y'all, because here's the transport. Here we go.
He hit a woman, he abused the woman. And I told him to observe and he put me in handcuffs because I was not in agreement with it.
Okay. I'm trying to get this process.
I'm praying for you right now. Don't talk to me. Like I'm really praying for your spirit.
Here we go. Transport continues.
He said the officer allegedly.
Oh wait, here we go. Pit stop. They get, so here it is. It's 4 a.m. They're at the police station. But again, won't give them her name.
Ma'am, I'm trying to get this process.
You.
Okay. I'm trying to get this process.
You.
Okay. I'm trying to get this process.
You. I'm praying for you right now. Don't talk to me. Like I'm really praying for your spirit. Take me where you want to take me. I'm not scared of you. I'm not scared of jail. I'm not scared of none of it. Take me where you need to take me. Take me where you need to take me. Stop harassing me.
All right, man.
I just pray for you. Take me where you need to take me. I'm not scared of you or jail. Please take me where you need to take me.
Listen.
No, I could give a. Take me where you want to take me. You're not going to harass me. And I can give.
Listen.
You. Stop playing with me. You have beat a woman and you beat me to the ground.
Ma'am.
Take me where you want to take me.
Hold on.
No, take me.
Hold on. Now she's saying you have beat a woman and then you beat me to the ground. Nobody anywhere, including the so-called victim herself, has said that a police officer abused her. In fact, they said the exact opposite, which was that there were no police on site.
And I don't care. You don't need identification. You have black people living. You have
Hold on.
you don't know.
He just asked her for identification. That's why she just said, I don't have to give you identification.
All right, man.
I just pray for you. Take me where you need to take me. I'm not scared of you or jail. Please take me where you need to take me. No, I could give a. Take me where you want to take me. You're not going to hurt.
All right. So what we're going through is YSD said, just getting here, rewinding, because why is she with Big Tigger? So she went on the Big Tigger morning show yesterday to tell her version of the facts. And what we're talking about is, and I'm going to play the clip again from Big Tigger, is what she said is she's saying that the police had a vendetta against her, that basically she is claiming that they held her for no reason in the back of a police car for 7 hours. Here, I'm going to show you that clip real quick, just so you're able to know where we're at. Here we go.
He had to come up with that whatever story whatever they were getting out, and he was nervous. He was visibly nervous, and he was making phone calls, private phone calls.
Wait a minute.
Oh, here we go.
So
Let's start talking about the police. Hold on.
That again, you're looking at the effects. You're not really understanding the cause. In that instance, if you've been violated, I don't know if you all have been violated by an officer. I don't know how you have been. In my opinion, honestly, I can't go too much into it, but what I think the officer was doing was trying to cover up his improper acts. He rode around with me for 7 hours. He arrested me at 3 o'clock, and I didn't get to the jail until almost 11.
wait, so okay, between that time, what were y'all doing? What was he doing?
He was antagonizing me. He was, remember, for 7 hours. Listen, the cuffs were so tight. I had bruises on my arms. I mean, listen, he was stopping his car and getting out, and he was nervous. He was visibly nervous, and he was making phone calls, private phone calls.
Wait a minute. So for several different hours, you're saying 7 hours. So from what time to what time?
3 until after 10. That's when I got to the jail. And I'm going to say that I believe he was trying to cover his tracks. He had violated me. And then when he found out, and he knew on scene that I was a judge, because once he put me in cuffs, people were like, that's a judge. So then I think he had to come up with that whatever story whatever they ran on the news. So
all right, there we go. With whatever story they ran on the news. And she said, mind you, she's a judge in a different county. So it's one thing to say she's a judge, but I never heard anybody say her last name. They did say her first name, but there's a lot of different, every county has 3 different types of judges. You have civil, you have criminal, you have probate, and even in addition to that, you have municipal, you have magistrate judges. So again, nobody's sitting around doing any of that. So again, she's saying she has no idea why for 7 hours she's in the back of the truck. And here is the officer asking her for her ID as he has pulled up to the police station.
Harass me, and I can give.
Listen.
You stop playing with me. You have beat a woman and you beat me to the ground.
Ma'am.
Take me where you want to take me.
I can't take.
No, take me. And I don't care. You don't need identification. You have locked people up, and you have picked up dead bodies when you don't know who bodies it was, but you picked them up.
Ma'am.
Take me where you need to take me.
I'm trying to.
No, take me where you need to take me immediately, expeditiously.
You're preventing.
Take me. I could give it. Take me where you want to take me.
You heard him say
now.
He said you are preventing that.
I pray for you. I promise I pray for you, because your life, you have a long life to live. I promise you. I pray for you.
Ma'am, I need your
I pray for you, sir. Listen to me.
So I can book you in so you can go on with your day. So you can go on with your day.
Sir, the last person that ever tried me like this died 30 days later. I pray for you. And I pray for you. My God.
Now she's warning him.
My God.
He could come up. He's warning the cop. He could come up dead like the last person come up missing like the last person who tried her. Again, he's asking her buku times. So who was it? 7 hours later, but she got there an hour later. Not even an hour, right? She was booked at basically 3:18 to 3:15. 45 minutes later, she's here. And the whole time, they're asking her for ID. She refuses. I'm a full fright. So this is the pit stop. She is literally refusing. All right. So they leave. He's not even sure what to do. This has literally never happened before. Mind you, under Georgia law, it is a misdemeanor to not give an officer your name, your identity, if either you're driving, that's because you need a license, or if he has probable cause to believe you've committed an offense. With her being in handcuffs and in the back of a car, he absolutely has probable cause, especially where she's shoved him, pushed him, whatever the allegation is here. So she's supposed to, under the law, she actually committed a misdemeanor and could have been charged for that, but was not. There you go. The rest continues. Now taking to right. She's refusing. At one point she told him, they have dead bodies that they transport without knowing the identity. Why do I have to give you mine? Here we go. So now he's taking her inside. So she's refusing. She's like, run my print. Now you see it's 4:10 in the morning. She's got the handcuffs on. He's trying to escort her inside. He's adjusting the cuffs. Look, the ones that she said.
Stop touching me.
So it is now, it says the time is now 4:10 in the morning. I think is what I see here. Yeah, it's 4:10 in the morning. The cuffs are now being adjusted for her.
Stop touching me.
I don't deny that the cuffs are probably extremely uncomfortable.
Don't touch me. Don't touch me.
But that's all the more reason why go ahead and give them your name so that they can do this.
Be a woman and think I'm about to watch it and be cool with it. You weird.
And I don't know what makes you think you can tell an officer who's trying to book you to not touch you. Like in what universe? 4:11 in the morning now. So it's about an hour later. She's here. And again, refusing to give her identity. So they can't book her without it. She doesn't need an ID. She doesn't need a license. She can simply give her name and date of birth.
Wadsworth.
And lost her wig and the wig cap. Yeah, both of them.
What's your name?
She says, what's your name?
I asked him to call somebody for me, and he did. So what's your name?
What's your name?
When I get to call somebody, please, I'll talk to you. I asked him to call Cyrus Colley.
She says, I asked them to call Cyrus Colley. So Cyrus Colley is someone that she knows in Douglasville County who is running for sheriff of Douglasville County. They are in Fulton County. These people don't know who Cyrus Colley is, don't care who Cyrus Colley is. And even if they did, Cyrus Colley has zero authority. It's also 4:13 in the morning. Cyrus Colley is probably in bed, minding his business. But again, she's refusing to give her identity and instead name dropping with the expectation that if this person were on the phone, she would quickly then be released. I'm going to go ahead and fast forward because it gets goofy and goofier. And I want you guys to continue to be able to see the timestamps on the So what happened was, again, she continued this whole time and refused to give her name. So what happened was they did do her prints, but she's not a criminal. So her prints didn't come up. Your prints only come up if you have prior criminal history in the criminal database. So again, but yet and still, even after her prints did not come up, she still refuses to give her identity. I'm going to fast forward so you can see how long these officers, poor things, had to deal with her. It's not 5, 6 minutes.
So he'll make come up. No, if he says you put your hands on him. No, he put his hands on me. Why would I look like you think I went out looking like this? I don't know. I look like this. That man put his hands on me. Then you put a hand on another woman. It wasn't me. Him. I don't know that. I don't even know the woman.
Remember, now she's saying both. She said he put his hands on me and another woman. Well, he's pulling the other one. Again, which one do you want? Do you want the woman to be whisked away from the gentleman to safety or not? Because in this instance, in order for that to take place, someone had to pull them apart because unfortunately you weren't able to do it and the other people there weren't able to do so either. So she's now saying he put his hands, she's implying that the cop assaulted the other woman and her, and the other woman has never claimed that. This woman is simply trying to get her identity to move this process forward because it's now been 2 hours.
Put his hands on. Well, I haven't
I want you to see some more of this footage. Let's see where it goes.
I was there. So you can ask the judge whenever that happens. All right. Put in Daniel.
This is just taking us to like 6 in the morning, but literally the sun comes up in these videos.
695. Actually, can show me around to Fulton County Jail with this female. Mileage 12693.
Okay. Somebody said Fulton County. A pimp said Fulton County needs their own reality show. They absolutely do. Man, you're right, Fran. Here we go. So the point is, all right, so we're going to go ahead and we're going to...
Tonight, tropical storm Alberto turning deadly as it slams Texas.
Listening to the Big Tigger interview, but that just seemed to be the biggest, boldest, craziest, provable lie that I just couldn't believe she even went there. Here we go. This is the rest of the Big Tigger interview with, let me share it here. There we go.
I asked him I said, am I under arrest? If I'm under arrest, I would
talking about the police officer.
Before I give you any other information, because if somebody ever lies on you, you need an attorney. We don't need to even have any more conversation. So that's what I did. I said, I don't want to give you anything. Mm-hmm. And moreover, I would have my license if you didn't knock me out and my purse got taken. You understand? You didn't even let me get my belongings.
Girl, they didn't let you get your wig.
Not at all.
They got it out there with the braids.
Correct.
Oh my gosh.
Correct.
No, ma'am.
Correct.
So,
correct.
What would you have to say about some allegations and people are saying that you were probably under the influence?
Not under the influence. I mean, I drink wine. I had a glass of wine, but it wasn't under the influence like that. What you saw was someone that was upset. What you saw, I was crying at times.
I did that.
Yes. And when I cry, I get shaky and like, and I'm really sensitive. People think I'm a real strong woman because I will protect anybody. I will fight for anybody, not physical fight, but fight under the law and fight with God's help. But I'm talking about
God's help.
You're not in trouble. You don't. That's not a crime to have a glass of wine. A crime is to drink and drive. A crime is to that. A crime is not to protect someone that's getting attacked. A crime is not to get a woman out of a grasp of a man who doesn't have the right to be holding her and detaining her. Who let the attacker go? By the way.
Really?
Yeah, absolutely. They never spoke to him. Here's the thing. I'm being charged with obstruction. The officer keep in mind when I was originally charged, it was disorderly conduct.
Right.
But then 7 hours later, it was felony obstruction.
7 hours later, it was felony obstruction because by refusing to disclose your name, you are literally obstructing justice. They cannot book you because your goofy behind refuses to give your name. So here we go. We're going to fast forward. I just want you to see how long it went. I want you to see the timestamps at the top. This is video. This is like a shorter version that's released by Atlanta PD itself. Remember, this was when they tried to, right here is when they tried to fingerprint her unsuccessfully. And they had to fingerprint her because she wouldn't give her name. Here it is. You see the timestamp top right? 9:26 in the morning. And they're still dealing with her because she's refusing to give her name.
Now, which one are you staying this too tight, ma'am? Because it's moving. This one?
This one.
Okay. Actually, I can't get it from here.
Someone said what we saw is rash judgment. You're right about that. Yeah, rash judgment. 9:26, and you still haven't given these people your doggone name. Girl, don't you want to go home?
I know I do. I don't.
You got to go to the bathroom or something.
You said you shouldn't be in handcuffs? Okay.
But when people
10 o'clock.
So,
it's now 10 o'clock. Top right.
You said I was charged with a felony. What's the felony? You didn't tell me that.
Charges continue to increase the more you piss them off.
This is the.
How many charges is it, sir? Because they went from 1 to.
I told you obstruction and simple battery.
Obstruction. What's you said felony obstruction?
Yeah.
What is felony obstruction?
Somebody said.
Same thing
Said that cop's side I was supposed to be off 2 hours ago. You're right about that. So here we go. So going back to the Big Tigger interview, the gist of it, like the biggest, craziest part, is she literally sat there and claimed that the reason her arrest was taking as long as it was taking. The reason her arrest was taking as long as it was because it was basically a conspiracy against her.
Regards to the under the influence, and no, it's not a crime to have a glass of wine, but there are people who will point to that. You look visibly
hit that like button
for some people.
Hit that subscribe.
I never say as a judge that you're held to a higher standard than the average person.
Mm-hmm.
The whole thing before your name is called honorable.
Correct.
There are some people who say that you weren't behaving honorably. What would you respond to those people?
Well, first, I don't know I haven't heard anybody who said I looked visibly other than the officer. That's the only person who said I was visibly intoxicated. I haven't heard anybody on the scene. There's a lot of witnesses. I have at least 10 who didn't believe that.
I think,
like I said, he's covering tracks. I believe that my language, like when I go back and look, it was that's not how I usually talk. That's very
That sounded like Memphis.
Listen, and I'm not from Memphis, but I don't know if you've ever. I used to be a prosecutor, and as a prosecutor, we fight for victims who are abused all the time. And it's like holla.
You used to be a prosecutor, then you should know good and well. Oh, she's in trouble. She's in trouble with the bar. If you used to be a prosecutor, then you know good and well what you can and can't do. You also know that you're supposed to give your identity in a situation like this where the officer has probable cause. Mind you, probable cause doesn't mean you did it. Probable cause just means there is enough evidence for him to believe that there is a crime afoot, that a crime occurred. And then everything else shifts to the procedures and the processes for due process for you to prove that, no, I didn't do anything. But given that you used to be a prosecutor, what I'm saying is the bar, when they make a decision on whether or not her license should be suspended, and I do not believe she should be disbarred or anything like that. But in a situation like this where the lies just continue and they're public lies that are specifically aimed at at discrediting the police. And the police, of course, in Atlanta already have enough issues. In no way am I defending them. But this is one situation where you literally have what's now a former judge and current attorney giving a bold-faced, obvious lie and claiming that the police were corrupt and that is why they held her in the back of a vehicle for 7 hours, when in fact, the reason she was in the back of that vehicle for 7 hours because she broke the misdemeanor law that requires you to simply give your identity to an officer in a situation like this. Someone said, great question. Jay Simmons said she wasn't driving. You're right, but that's not the law. The law actually says let me see if I pull it back up. I'm going to pull it up for you. I want to share this with you. I'm so glad that you asked. That is an excellent question. We're going to share this real quick. The Georgia law actually says you don't generally need to show ID unless you are driving or an officer has probable cause to believe that you have broken the law. Here, That's why she's in handcuffs, arrested, and in the back of a police car, is because he believed that there was probable cause. And so at that point, that's when her obligation to give him her identity. And the thing is, if you don't have your driver's license on you, that's fine. You just have to give them their name and your date of birth, and you can't lie about your name, and you can't lie. Oh, they were talking about the breathalyzer. Oh, you're right. Yeah. No. She doesn't have to do the breathalyzer. But I just wanted to make sure, people just knew that part. All right, so here we go. Back to Tigger.
When I
It's
saw
almost
it
done,
personally
y'all.
firsthand,
about
I just that's just where I went with it. And the problem is, if you know you're not an officer, that's not how I usually talk. That's very
That sounded like Memphis.
Listen, and I'm not from Memphis, but I don't know if you've ever. I mean, I used to be a prosecutor, and as a prosecutor, we fight for victims who are abused and all the time. And it's like when I saw it personally firsthand, that's just where I went with it. And the problem is, if you know you're not an officer and you don't have a right to be holding this woman, when I asked you to let her go, I'm grabbing on her arm and I'm asking you to let her go. Why didn't you just let her go? I mean, you wasn't helping her. You didn't investigate.
It was a lot of chaos. It was a lot of chaos.
Hold on. Wait a minute. Y'all just heard that? She just said, if you're not arresting her, why didn't you let her go when I told you to let her go? Let's hear that again.
Saw it personally firsthand. That's just where I went with it. And the problem is, if you know you're not an officer and you don't have a right to be holding this woman, when I asked you to let her go, I'm grabbing on her arm and I'm asking you to let her go. Why didn't you just let her go? I mean, what was the
Okay, I'm sorry. I thought she was referring to the officer. She's referring to the security guard. But I think that's where we have that's Karen mentality. She says, I told you to do something, you should have done it. He does not know who you are. And even though you are the very beautiful, I think she's very beautiful, the very beautiful Judge Christina, just because you tell a man to do something doesn't mean he has to do it. In the same way that you are telling him to do something, he doesn't have to do it. He don't have to do what you say. You sound crazy. And the fact, one of the descriptions that the Judicial Ethics Committee gave and used to her, they called her vainglorious. I ain't never heard that word before in my life. And I did quite well on the SAT, took it a few times, but vainglorious is what they call it. And basically it's like above the rules, above the law. So she's literally saying, why didn't you let this girl, why didn't you do what I told you to do, Mr. Stranger Man? Girl, you're not okay.
You wasn't helping her. You didn't investigate.
It was a lot of chaos. It was a lot of
chaos. Oh,
wait,
no. She said you weren't helping her. You didn't investigate. She's implicitly referring to the police too. Police don't have to take your instructions. That's why there are literally different branches of the government, right? We've got the executive, which is like Congress and the president and stuff. Well, it's the president. We got the executive. We've got judicial, which is judges. And then we've got the other branch that like covers police and stuff like that. They literally don't have to do what judges says, and they have to be independent for a good reason.
If a woman has been attacked and she's traumatized, why do you have her in your grasp?
I was just surprised because you were the only one to come to who I thought this was your friend. Because I'm like,
I didn't know any of these people.
Oh, wow.
I didn't know the man who was attacking her. I didn't know the girl. I didn't know her friend. I didn't know these people. I just knew it was inappropriate. And like I said, that would be my, like I said, you're going to see what they want you to see. Even when they release the body cam, if you notice, they put narrations at the bottom. She ran up and she rushes up and strikes the officer. You don't see that in video. See what happens with video? A video speaks for itself. You don't need narrations. They're wanting you to see what they want you to see. So if you look at it without the narration, see what you see. Play it in slow motion and see what you see.
Again, former Douglas County Judge Christina Peterson here with the Big Ticket Morning Show on V103. What's next for you? Where do you go from here?
Well, I mean, I'm going to continue to fight for the people. I've always been, like I said, a high performer. I'm still an attorney. I'm still doing great things. I'm multifaceted. I still have other talents. I do acting and sing on the side. So I'll continue to do what I do. Nothing is stopping for me. Just the bench is the difference, so that's the only thing. I'm going to continue to do good work. People are still going to retain me because I fight hard. Listen, before I became a judge, I never lost a case. I never lost, not civil, not criminal, never lost a case. Now, when I became a judge, because they're attacking me, they've dismissed and tried to fight me in the court of law with their judge friends. But before this, I've always won. I never lose. So I'm going to continue to win.
Thank you for joining us this morning.
Thank you.
There we
If you
go.
want to get in touch with you or stay in touch with you, where do they go?
You can, I am this generation, so we're on Instagram. So you can go to Official Christina J. Official Christina J. A lot of people have been following my Peterson for the People page, but my main page is Official Christina J. So
there we go.
Well, listen, if Trump can still run, hey.
Yeah.
There you have it.
If you want it done right, listen. If you want it done right, don't listen to what you hear in the news. See what the person, what that work that person does. Nobody has run that probate court better than me, and you better understand. You can go up to talk to any of my girls that work there, and they will tell you that they are upset about the decision and upset that I'm not there. But I'm still covering them and I'm still praying for them over there in Douglas County.
I would have liked to hear her description of what really happened in her view with her locking the woman up for 20 days for trying to correct with the woman believed to be an error and a typo on her marriage certificate, but as far as the name of her father on the marriage certificate, that's fine. All right, we got some comments here I want to make sure that I get to. And then now we're going to talk about how her removal of the bench, how that impacts the YSL trial. And you're getting it here first. This is Girl Is That Legal. My name is Attorney Simone Redwine. This is Girl Is That Legal. Make sure you hit that like button and hit that subscribe. My goal is by the end of July, my hope is to get to 25,000 subscribers. That'd be awesome. I used to have a channel. That channel, I had 25K, but I lost it because of stuff I'm not getting into. All right. This was a great question. Fran said they should have booked her as Jane Doe until she gave her name. Actually, at one point, this was around 5:30 in the morning, the officers were like super frustrated. When you saw there was a Black female officer that came out and was trying to talk to her in the vehicle, they actually had discussed that. And one of the officers says to the other, I don't know if we can still do that. So that was something that in the past that they had done, but they weren't sure if that would even be possible. Someone else said, I'm convinced she has some type of health issue. I say that to say, if I were her attorney, what I would negotiate with the state, because this was a lot. This is a lot for anybody, self-inflicted or not. What I would negotiate with the bar and with that judge is, hey, she has some either undiagnosed or she has some type of trauma. She's going to go into treatment. She's going to go away. She's going to go into inpatient therapy, and that we ask for leniency from the bar, because there's something called, it's the Attorney Assistance Program. It is amazing. You have health insurance, you don't have health insurance. It actually covers rehab for attorneys who need it. That's because attorneys are the number one profession. It goes back and forth actually between attorneys, doctors, and dentists, between professions that have the number one rate of addictions and the number one rate of not waking up in the morning, unalive. So therefore, every state has a lot of resources for that, as well as the bar. If they know that you're working on yourself and you're going through that process, they will be more lenient with you. So that's what I would do immediately if that was my client. But the problem is that requires you to actually have some sort of remorse or to believe that you've done something wrong. And I don't believe that she thinks she's done anything wrong. The way that she was able to flip it and accuse the officer of hitting her as opposed to arresting her. There's no question he arrested her. There's no question that he spun her around, put her down on the ground, and put her in handcuffs. But I didn't see, and I could be wrong, I didn't see a punch. I didn't see an attack. I didn't see any of that on her or the other young lady. Somebody says she's wrong. Oh, but we'll ask why she didn't get a breathalyzer. So yeah, there's no reason to give someone a breathalyzer. And you actually, as an officer, you can't even attempt to give someone one of those if they're not driving or attempting to drive. Like even if you find someone like asleep in the back of their car, they can be given a breathalyzer or attempted to do so. But here, where the incident occurred on land, you'll say, that wasn't necessary. Yeah, she does seem. Yes, someone said she would have done herself a favor by being quiet. All right. So here's what's interesting. So let me go to it. There we go. All right. So the way that I'm going to pull this from the screen. One of the areas that this could most impact the YSL case is when I say this, I'm referring to the fact that the Georgia Supreme Court removed her from office. And they removed her from office for various different counts. I think ultimately, of all of the counts, they found that 20 were grounded. In those 20, according to her, she says they were basically surrounding 5 separate incidents. So certain incidents may have multiple counts in effect. That's what she's saying. I haven't fact checked that. So I'm presuming that is true. One of the major events was what's called an ex parte communication. And it was claimed that she had an ex parte communication that was unacceptable. Here's what ex parte communication is. And the same allegation has been made in the YSL trial. An ex parte communication means the judge is communicating with one side without the other present. There are very, very, very narrow incidents of when that is acceptable. I'm going to read you the facts surrounding her ex parte communication, and then we're going to compare that to the ex parte communication in the YSL trial. Now, to summarize the ex parte communication in the YSL trial, is that in the YSL trial, attorney Brian Still for Young Thug was livid when he learned that, I believe it was whatever day of the week it was, they were all told to show up at the courthouse at 9 a.m. They were there at 9, but court didn't start till 11. He then learned that it was because the prosecutor called Lil Woody, it's actually Woody, it's not Woody, called Lil Woody and Lil Woody's attorney into the judge's chambers and had a conversation with him. And that in that conversation, the judge effectively threatened him with jailing him if he did not testify that day. Now, initially, Lil Woody, and this ex parte communication occurred because the prior, I believe it was like the prior Friday or what have you, Lil Woody said he wasn't going to testify. He got on the stand and he kind of acted a fool. He said he wasn't going to testify, and therefore the judge held him in contempt because of the fact that he had already been given immunity. When you're given immunity, you must testify. You cannot plead the fifth. There's nothing to plead the fifth on. The pleading the fifth is because you do not want to incriminate yourself. In other words, you don't want to risk the likelihood that you could be incarcerated for what you say. Because he had been given immunity, there was no chance he could be incarcerated for what he said. Therefore, he needed to testify and to testify truthfully. So the judge locked him up over the weekend. In the ex parte hearing, the ex parte meeting that was in the judge's chambers. Now think about it. You've just been locked up over the weekend because you wouldn't testify. You then get called that next, business day, called into the judge's chambers along with the prosecutor and along with your own attorney to be told that if you don't testify. So what he said is, I'm not going to testify. I'm just going to sit. I'm just going to do 2 years. He said, I'm just going to do my time. He didn't want to be known as a rat. I'm going to do my 2 years because that's what he believed he would be limited to. In that ex parte communication, they informed him, the judge informed him it wouldn't just be 2 years. It could be indefinitely. That's what made him change his mind and say, oh, hell no. Sitting for 2 years is one thing. Indefinitely, no, I'm not doing that. Then he got out there and testified. So that was the ex parte communication there. And that is why it is so serious. Yes, I love your channel. Y'all go to the Paralegal Institute of Washington, D.C. Go to their page. It's a good topic. We talked about this on our channel. Wait, what is this? Go away. No. Okay, there we go. Let me see. We're going to decline. Sorry, I thought I had my do not disturb on. Let me make sure I put it back on because I'm definitely getting disturbed. There we go. All right. They say, which ex parte situation do you think was worse, Peterson's or Glanville's? Definitely Glanville's. Peterson's was like this. So I'm gonna give you the summary gist of what Peterson did, and then we're gonna read it because the way my ADD is set up, like I lose attention quickly. So the gist of what Peterson did was there was basically a contested will situation. So there was the wife of the person that died, the decedent. There was the wife, and then that person that died left a daughter. The two of them were not in agreement over effectively how certain property should be handled. So there needed to be a hearing, and basically the daughter, who is the other living heir, needed to be given the opportunity to file a response. So what happened, the gist of it was she was notified by the court that, hey, we're going to have this upcoming hearing, and that therefore, if you're going to file a response, it needs to be by this date. And you basically have to submit your response, and you have to submit the filing fee. I believe she submitted the response, but not the fee. And that Judge Peterson's chambers contacted her and said, hey, we got your response, but we didn't get your fee. Now, when you do that, you're supposed to include the other side. The best way to do it is it's usually all done via email, and you just email all sides. The problem with them, they effectively gave her an extension to contest. And when they gave her the extension, it allowed her to successfully contest it, blah, blah, blah. And the attorney for the wife said, hey, that's not fair. One, we weren't included in that communication is the main issue, and that you can't communicate with one side without the other. So here's what it says. So specifically, I'm going to share this. Let's see. There we go. We've got. All right. So effectively what they're saying is the hearing panel's finals are not clearly erroneous. Okay, so this is with respect to the counts pertaining to ex parte, the hearing panel found the following facts pertaining to her handling of a petition for a year's support. A year's support is effectively, let's say your dad died and you have a stepmom. That stepmom is saying, hey, there's this money in the bank. There's all this stuff. I'm asking you to be able to pull out from the bank accounts, the money that, you know, my spouse left over, enough to take care of me for a year while we work out this will stuff. That's kind of the gist. It said the petition listed the petitioner's daughter as an interested party and provided her out-of-state address. Judge Peterson's chief clerk sent by certified mail with restricted delivery notice a notice of the petition to the address that was provided for the daughter. The notice set the deadline to submit a petition by May 3rd. On April 5th, the signature card for the certified delivery notice was returned to the probate court with a signature from someone else, not the daughter. The judge's chief clerk then asked Peterson to search LexisNexis to obtain an alternate address for the daughter. The judge concluded the search and found the daughter's email. Judge Peterson's chief clerk emailed a second notice to the daughter, setting a new deadline to file, basically giving her an extension to this July 10th date. No, she did this simply, that email that they sent to her, all they had to do was include the attorney for the wife as well, basically the attorney for the petitioner. All right. Then it says, the daughter eventually mailed her caveat to the probate court's office. The chief clerk and the daughter then spoke by phone, can't do that. And the chief clerk asked about the status of the original document and the filing fee, which were both required for the filing. The daughter said she mailed the filing fee. Chief clerk assumed that, it must have been lost in the mail, and ultimately took payment from the daughter over the phone and filed the caveat July 14th, 4 days after the deadline. This is important because if she doesn't make the deadline, effectively, it means the petitioner won. The court effectively gave the daughter a second chance after losing. None of the chief clerk's communications with the daughter included counsel for the petitioner. The hearing panel found that although Judge Peterson's staff, including the chief clerk, knew that ex parte communications with parties to a proceeding were prohibited, the Judge Peterson clearly failed to conduct the proper oversight to ensure that the chief clerk was not participating in these communications. Okay. So going down further into this, it says now it's going to break into, this is the CJC rule that pertains to ex parte communications. So what we're breaking down is we're comparing, this is the allegations that basically that the state of Georgia made against Christina. This is one of them that they used to determine that she should be removed from office. And the gist of it was that she had an ex parte communication with a party. She should have included both sides of a probate case, but she didn't. And then we're going to compare that to what Judge Glanville did here in the YSL case. So again, here it says, we turn to the violation. By accepting and considering the daughter's emailed caveat, which is basically her answer, of which the petitioner and her counsel had no notice, Judge Peterson permitted and considered ex parte communications in violation of the law. And as the hearing panel noted in its report and recommendations, none of the exceptions in the rule applied that might authorize ex parte communications here. An example is in the context of examining the denial of a motion to recuse. We don't care about that. Authorize ex parte communications with respect to scheduled hearings. So, for example, an example of an ex parte that's not a big deal, that's okay, is if I call up, let's say, I call up and I say, oh, Your Honor, I'm not sure. My calendar says we're supposed to have a hearing on Monday. Is that still happening? Not a problem. If they say, yep, Ms. Redwine, we're still having that hearing. That's totally fine. That's something that's administrative and ministerial. It says, by failing to promptly notify the petitioner's counsel of the second notice of the petition that was sent by the daughter via email with an extended deadline, she violated the rule. So basically, this was more than just informing someone of something. You've now given them a second chance after they missed a deadline. So in effect, you've given them a second chance to win when they didn't follow the rules the first time. If you're going to do that, you simply got to let both sides know, because the petitioner here, which would have been the ex-wife or the decedent's wife, has a right to say, Your Honor, don't give her a second chance for these reasons. It says, Judge Peterson, by failing to provide the proper oversight to her own chief clerk, who sent the daughter the second notice of the petition and spoke to the daughter on the phone about the case without notifying the petitioner's counsel of these communications, she violated 2.9D because she failed to make reasonable efforts. And keep this in mind for the YSL case. A judge must make reasonable efforts, including providing appropriate supervision to ensure that the rule is not violated by court staff or officials and others subject to the judge's control. In addition, okay, there we go. Accordingly, the judge violated the provisions here. And specifically, it says, impending matters and pending proceedings are only as good as the parties make them. Neutral and detached impartial judges should not be concerned about changing up things in cases. Here's the issue. Judge Glanville sure doesn't seem neutral and sure doesn't seem impartial. Because in comparison, what Judge Glanville did, in my view, is so much more egregious than this. Honestly, comparatively, this seems petty. Part of the reason I say that this seems petty is Judge Christina made a good point. In the Big Tigger interview, she talked about how a lot of the claims against her had to deal with her supervising the staff. Well, this happened within the first 3 or so months of her taking over her role. And most of the time, a lot of the staff is the same as what was on board with the prior, unless, she's different. So she very well could have fired a lot of the people that were under the prior judge. So when your ethical issues are failure to properly supervise, probably what her claim is that is, hey, this is how they had been doing things under the prior judge. The problem with that is you have to act like that prior judge never trained anybody. Okay. When I was a judge, I could never say, well, this is how the other judge did it. Wrong is wrong and right is right. In fact, I chose to step down to my position as a judge because the stuff that the prior judge was doing was all kind of wrong. I'm not going to jail with you, sir. I'm not doing it. You can go by yourself and I'll tell the news all about what you did. So, oh, thank you, Coffee Cup. I love it. My lips are going 75 miles an hour. I hope you're not talking about me. Oh no, you're talking about girl in the video. You're talking about Judge Christina. Yeah, here we go. But also know that Judge Christina was talking fast because I did speed it up a bit. My point here is that what's most important to understand about ex parte is that one of the things that makes the conversation that was held in Judge Glanville's chambers so bad is that the witness had already been sworn in, which means he's already been sworn to tell the truth, the whole truth. And now that you're putting this pressure on him, this impacts his ability to do so. Particularly, the other side is entitled to know anything that would, the rule is Brady is one of the rules. Anything that would help to present that if presented to a jury would make that jury feel like, okay, this witness's testimony has particular reasons where we need to dismiss it, where we should not give it credence. One of those reasons would be if a judge brings you into chambers and threatens to lock you up indefinitely for saying what you said. So going further, it says here, as the hearing panel has noticed, This is about Judge Peterson. So we're going to compare. It says, even if Judge Peterson did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. We agree. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with the party in order to unfairly advance that party's interests and jeopardizes the appearance of independence, integrity, and impartiality of the judiciary. Because Judge Peterson's inappropriate actions taken in her capacity, even if done in good faith, appear to be unjudicial and harmful to the public esteem of the judiciary, her conduct is prejudicial to the administration of justice, and discipline regarding these counts is authorized under the Georgia Constitution. I'm going to say all that, and I'm going to put in the name Judge Glanville, and I want to hear what you guys think. It says, Paralegal Institute says, we try to present the information from a neutral perspective or else give both sides perspective. The problem is that to date, Glanville, which is the YSL judge, has not offered any explanation for his meeting. Exactly. That's the issue. He's more right now. Glanville was more concerned over how did you find out? That how did you find out is going to get him in a lot of trouble. Because if it's not a problem, it doesn't matter how he found out. It doesn't matter. Hit that like button. Thank you. It does not matter, right? So if you're that concerned, he says, well, my chambers were breached. No. Now, if he's having a one-on-one with the prosecution, and there are still issues with that, but it's one thing if you have an ex parte with you and the attorney for one of the side. When you pull in a witness who is sworn in, means they're now told they have to be honest, right? And by sworn in, what that means is you pulled in a witness that's in the middle of testifying. That witness is supposed to be independent. They can't be independent anymore. When you pull in that witness who's in the middle of testifying, you've violated the integrity of the entire case. Here's what's interesting about Judge Christina's case. And I'm calling her Judge Christina just because it's easier to flow out of my mouth. I think one day I was calling her Judge Pearson instead of Peterson, so forgive me. I don't usually call people by their first names, but for Judge Christina's case, because I believe she's about to get a judge show after this, right, Judge Christina? In her case, when this happened, a motion to recuse was filed by the petition. Do you know what she did? She did the right thing. She recused herself. She said, ain't nobody got time for this. Like, this is petty. This is silly. I'm going to recuse myself. Glanville has been asked buku times to recuse himself every time he says no. You know what else Glanville has? He's up for election. He's up for election this year. When you're in an election year, those are some of the prime times. And I'm not sure if he has an opponent right now, because what happens in a county like Fulton County, that's majority Democratic, if you're going to have a opponent, it's going to be in the primary. That's because once you get to the November election, people generally in Fulton County, the winners for the judge seats are going to be whoever the Democratic candidate is, because the majority of everyone is Democrat. Now, but because this is an election year, I believe that's part of why he is even more committed to not pulling himself off the case. But by him doing that, he's absolutely risking a mistrial. He should have, at a minimum, there's now like hearings and stuff that are going on regarding the contempt hearing for Brian Still. At a minimum, he needs to remove himself from overhearing Brian Still's contempt hearing. The reason why is because the Judge Glanville, is a witness. Under the law, you cannot be both a witness and preside over a case. Are you crazy? That sounds insane. And you legally can't do that. In fact, you can't both be an attorney in a case and a witness. So that is why for Brian Steele's appeal of the contempt hearing, Brian Steele actually had to hire an attorney. It's his wife, but still he hired someone else because he has to serve as a witness in this. So comparing the two, Judge Christina, in her ex parte situation, yes, it was wrong and it should not have happened. But at least she, when she was presented with a motion to recuse herself, she recused herself. So that helps to alleviate some of the issues. Ultimately, what happened was she recused herself. The new judge came in. That new judge found in favor of the petitioner, which was the wife, and dismissed the late filed petition of the daughter. So effectively, did not give the daughter who filed late as a result of the ex parte communication, did not give her that benefit. Somebody said, what about a lawyer? What about my lawyer is now a judge and gave me time? Can't happen. Nope, that's improper, impartial. Definitely file a, that lawyer has to recuse themselves. I don't see any way that a lawyer could not recuse themselves if it was the exact same matter. Now, let's say it was criminal and they represented you in a different criminal matter in a different time. But even still, the problem is you have to ask. Most of the time, you have to ask for recusal. Although I've had situations where judges have sua sponte, meaning on their own, recuse themselves. So I ran for judge. I ran and I became friends with other women who were judges. And then I at times had a court in their case. And I was glad. I was like, oh, yeah, I got this case in her court. But I had then judges that recused themselves from the case because they were like, no, I know Simone. So, oh, thank you. Glanville is running uncontested. That makes sense because, like I said, the primary is over. And if he was going to have an opponent, it would have been in the primary. But still, I believe he's the head judge for Fulton County. So that's another reason why he's not going to recuse himself. It's very rare that you'll find a judge recuse themselves in a high-profile case like this because part of their concern would be the new judge effectively has to start all over. The case doesn't have to start all over. That's why recusal is better than mistrial. Interestingly, the other thing Judge Glanville did that was crazy, it was so crazy that even the prosecutor didn't let him do it, was that when he got so hot with this, let me see, and I'm going to play that clip for you guys too. Here we go. We're going to play that. Yep. He got so mad about everything that he literally, he was going to lock up Brian Steele and then still make Young Thug proceed without Brian Steele serving as his attorney for the day. Sir, are you crazy? Are you nuts? Must be. You got to be. That was literally on my bar exam because you can't do that. And the reason why is you cannot preclude someone from having their choice of a lawyer, especially when their life and their freedom are on the line. So by locking Brian Steele up for the day and saying he couldn't, that someone else was going to need to take over and proceed with the trial, that the trial had to go on and they weren't going to wait for him, the judge was absolutely creating a mistrial. And it was so obvious that the prosecutor himself, when he said that, the prosecutor goes, Your Honor, can I have a moment? I want to confer with my co-counsel. Goes to the co-counsel, comes back and says, Your Honor, we have conferred and we're okay with, you can continue to hold Brian Steele in contempt, but we're asking that you allow him to continue to represent Mr. Jeffrey Williams today and the proceedings for today, so that Mr. Williams can have the counsel of his choice. You think? Why is the prosecutor teaching the judge the law? That's another indication that this is all a monkey circus. This is a circus. I say monkey not because we're Black people. I'm saying monkeys because when you have a circus and you got craziness going on, I'm actually thinking I want to go to the Universal Soul Circus is coming to town, so something down. But this is a circus. So specifically, the state did that because without question, no questions asked. If you prevent, even for one day, if you prevent the defendant from having the lawyer of their choice in the middle of a trial, it's a mistrial. And it doesn't matter. Even if a jury were to find him guilty, the appeals court has to overturn it and set for a new trial. Whole thing, set for a new trial. It was actually a case in the state of New York where a judge, basically the same thing, a judge ruled, I believe it held the lawyer in contempt or the defendant in contempt, and stated that over the weekend, they were in the middle of trial, criminal trial, stated that over the weekend, the defendant could not communicate with his attorney. Oh, maybe that case got turned over so quick. But the problem becomes during the whole course of that appeal, if the defendant is found guilty, they've got to serve time. They got to sit in jail, all while this appeal is making it through the circuits. So thank you. Here's this Chief Judge. This is why local elections matter. It absolutely does. I guarantee you in 4 years, so it's going to be 4 years till Glenville has to run again, he's going to have an opponent. If he's still there, he's going to have an opponent. But this case, this little kangaroo court circus, oh yeah, the waste of county resources is impeccable. But I am particularly interested in seeing how I thought it was particularly interesting that it was so egregious that even the attorney for the state sat there and was like, oh, no, Your Honor, you can't prevent Brian Steele from serving as the lawyer for the rest of the day. They didn't even say it. They didn't say it that clearly, but we all knew that's what they meant. They were like, oh, no, we're okay with allowing Brian. And if the state hadn't said that, they would have made Brian Steele's like second or third in command. We don't even know how much that person knows, serve as the lawyer. Do you know that person that he was trying to force to be the lawyer for that day? That person said, no, Your Honor, I am not equipped. I am not familiar enough with the case to serve in his absence today. I cannot do it. If a lawyer tells you that, but the judge was insistent that he go anyway. Sir, are you crazy? Got to be. You've got to be. Oh, there we go. Somebody says, A2R, and hit that like button, y'all. Hit that like, hit that subscribe. A2R says, it's been my experience that ego and hubris are choking hazards. It would be seen. We are watching him choking on TV. Yeah. AR also says, the part that's most disheartening is that this foolishness is going to steal time from the defendants. They know that appeals take forever. That's true. Now, here's a clip. And I have it on speed. This is a clip from, here we go, Law and Crime from the judge trying to force Young Thug's attorney off. So we're going to watch it together. And I have it on sped up.
That the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
This is a Law and Crime legal alert.
Let me clarify. Hold on. Let me clarify. There are a few instances where ex parte, I want to be clear on like the types of instances where it could be okay to have an ex parte communication, meaning communication with one side and not the other. And that would be a situation such as one of them would be like if I go to the judge and I'm like, hey judge, I really need an expert. This is a criminal trial. I need an expert because I need an expert to be able to contest what the prosecutors are saying, was the ballistics evidence. So I need Your Honor to approve a budget, for this expert and or, basically like a budget or something like that, especially if it's court appointed, because the court has to approve the budget. That you can do all day, right? Part of the reason being is you don't want to have a conversation with the judge, with the other side there, when you are discussing the legal strategy effectively that you're going to use to contest the other side's expert. But that's one of the rare instances in a criminal trial when you can have ex parte with the judge. But again, even in that situation, you are not having ex parte with a judge and a sworn witness that's in the middle of testifying. That is the nutty part. Here we go. Acted a whole fool. Wrong. Hold on. Are y'all able to see it? Wait, I don't think it's playing on your side. Wait. Hold on. Is it playing on your side? It doesn't look like, it looks like it's frozen. Well, I'll keep going. Y'all let me know. Y'all don't hear it. Okay. Let me reshare it. Hold on. I'll reshare this one. Here we go. Oh, hold on. Here we go. Wait. Oh, here we go. Hold on. Let's do. There we are. And here we go.
That stand on that point, because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
This is where he keeps trying to ask him, how'd you find out? How'd you find out?
Do that. Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but
Can you hear it
that's
now?
improper, sir.
Your idea may be wrong,
There you go.
and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge,
Why? Why was he not meant to hear this information at that particular time? That's the key question. The judge says to Brian Steele, you cannot eavesdrop and get information that you were not meant to hear at that particular time. The question becomes, what problem would have occurred if Brian Steele was allowed to attend that meeting? I'll wait. Oh, what problem? Justice? Perhaps. I believe that the problem is exactly why he wasn't invited. The problem is, if he was invited to attend that meeting, then Brian Steele would have argued exactly what he's arguing now, which is that, Your Honor, you guys are illegally, unlawfully putting pressure on a witness in the middle of testifying because you don't like the testimony. And that, without question, is impermissible.
listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information and belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then
Here's one thing you need to make sure that you understand too, is that when this started, the jury was in the room, right? When it first started, basically, Brian Steele said, it's come to my attention, something along the lines of, it's come to my attention that there was a meeting and we have some concerns about it. And it was then that the judge dismissed the jury. So I want to be very clear. The jury really is unaware of this argument. I want to know in the chat, do you feel that a jury should have known about this? And I'll tell you, the reason the jury was dismissed by the judge is the judge knows that if the jury hears this argument, they're going to find in favor of the defendant. The jury is going to feel like, oh, it's some shady business going on. The judge, in the judge's words, he would find that this conversation would be more prejudicial than probative. Probative meaning relevant. It would be more prejudicial to the mind of a juror than being relevant. Therefore, that's why he kicked them out. But it's important to know, because some people are like, oh no, the jury heard it and the jury's going to know about that. And then the jury's going to feel they're going to lean more in favor of the defendant. No, the jury actually, they only got to hear that little piece in the beginning, which, depending on how much they heard, could be favorable. They could be like, wait a minute, this doesn't sound right. But the jury instructions are going to tell them that they have to dismiss anything like that. They're actually not allowed to even consider that any of this thing happened. Can we get some likes? We only have one like. It says, but we've got 237 people in the chat. Can we get some likes? Please, 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 y'all. The likes are part of what helps YouTube decide to recommend this to others. So what we're doing is we are breaking down and we are watching this clip of Judge Glanville going at it with Brian Steele in light of the Georgia Supreme Court finding that when Judge Christina Peterson did this exact same thing, she should be removed from the bench. Oh, Robert Rosencrantz said, "That's my like. Thank you." TR hit that like when he came in. Thank you. We might need to just recalibrate.
Okay, well,
those likes.
then you'll be in custody until then because you need to tell me how you got the information. I'm not asking you what was said.
Why would anybody
You've
tell
already
him
kind of given
how?
us some snippets of what you said. That tells me that somebody parroted that information to you. So
But you're assuming something because I told you already.
well, then other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton. Or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript. There's only one other person that's left.
Well, Your Honor.
What does it matter, Judge?
That information.
What does it matter who told him? In no universe is the fact that an ex parte meeting occurred a secret. There's what? You sound like a whole fool, sir. And you could be my daddy's age. You sound like a crazy person. In no universe, in any state, in any of the Americas, is the existence of an ex parte meeting a secret. That's the whole reason why courts say you're not supposed to have them. Quote unquote, the Georgia Supreme Court said in Judge Christina's case, even if taken in good faith, ex parte communications appear to be, quote, unjudicial and harmful to the public's esteem of the judiciary, and that her conduct when she did it was prejudicial to the administration of justice, and discipline regarding those counts is authorized. In other words, public confidence in the independence, integrity, and impartiality of the judiciary is impacted when you do this, and it weakens, quote, the public perception that the judge has afforded all of the parties the same right to be heard. Excuse me. So that's a violation of CJC Rule 1.2a. Judge Glanville did it, and Judge Glanville must be punished for doing so. Let's keep going.
Information or share that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have
when I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
What difference does it
To know
make?
what information happened outside of presence. That's really it.
He can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with the witness outside of our presence.
And whenever,
yes, wait. Look how the cop is rolling up on him.
Influence the witness.
I feel like he's about to fight him. I know the cop is about to arrest him.
All right. I mean, I don't know why that's so hard to do. If nothing happened, Dad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day. That's for
another day.
I didn't know about this stuff.
That's for another day. So
hell, forget your other day. No, you trying to lock me up? Tell me today, because today seems very important to you, Your Honor. That's for another day. No, that's because the judge is trying to figure out who said what. That's for another day. The existence of an ex parte meeting should never be a secret unless what you did was wrong.
So
and he knows he
as
was
soon
wrong.
As we found out about it. Well, I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material.
When a judge speaks with a witness outside of both sides, it's a major issue and it's grounds for a mistrial. Let's just flip the facts, because the way my ADD mind is set up, I learn well through analogies and examples. If the judge did that with Brian Steele and Young Thug and Woody, everybody would think he was corrupt. The state would have his head, and everyone would assume that Young Thug paid off the judge and, was having this side conversation for that reason. That's kind of stuff that the cartel does, okay, in third world countries. We just don't do that in America because it's not there.
Material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says.
That's because a sworn witness means a witness in the middle of testifying. Just think of it this way. If you were in the middle of testifying, let's say it was a child custody case, and you're in the middle of testifying saying that someone should lose their custody of their child because you saw them do such and such. Let's say the court pulled you in and had a meeting and said, hey, you haven't really been giving clear answers on the stand. If you don't complete your testimony and give us clear answers, I'm locking you up indefinitely. That's what he told Lil Woody. He said, if you don't testify tomorrow, the next business day, or you don't testify today, is what he was telling him, I'm not locking you up for just 2 years. I'm locking you up indefinitely. And that's when Lil Woody was like, well, guess I'm testifying.
And you did it.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what
Watch
I'm
it
trying
get
to
this
get to is why
stuttered.
did that happen
He
outside of
just
presence?
flip
And I
a
need
flabber.
to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it.
I want to
and
see
then
this
anything that
transcript.
is not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't.
So 1.6 is attorney-client privilege. And that absolutely could be in play. For example, if Thug was informed, so basically, if whoever told him this information told him this as part of like the legal strategy and the approach to his case. So what he's saying is, I can't give you my sources. And the judge is saying, I'm not asking you what the source said. I'm not asking you the content of the communication. I'm asking you who made the communication. Now, in this instance, the other reason why, if I were Brian Steele, I wouldn't tell him either, is you know that the judge is simply going to use this to punish the person. And that's exactly what this judge did. Keep watching.
You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information.
I know that.
Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there. Unless you're sitting there and you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with and then stand on, well, hey, we didn't give you the information.
No business getting to begin with.
Didn't give you the information.
Stupid.
So,
Your Honor, that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right.
Just
under Georgia
stop.
Why
Constitution.
can't the
Stop at
judge
this
answer that?
because
That's what I don't understand. Why can't the judge explain? Just simply say you were excluded under rule such and such. State the rule. He can't state the rule because it don't exist. He's making it up as it go. And the truth of the matter is, it appears that the judge simply expected Brian Steele to not find out about it, or to find out about it after it was too late.
Article 1,
Because
Section 1,
you
paragraph
you've
4.
already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes. Madam? Ms. Love?
And Your Honor,
He done pissed me off.
and I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms.
okay.
Love.
I know that's right.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication.
At an absolute minimum, Brian Steele should have been informed, hey, instead of starting at court at 9, we're going to start at 11. The state has requested an ex parte meeting with myself. I will be having that meeting. Thereafter, we will resume court. Why couldn't you have done that? Because he knew, as in the judge knew, good and gosh darn well, if he said, I'm having an ex parte meeting, he has to say, I'm having it with the state and the witness in the middle of testimony. and all hell would have broke loose. All hell would have broke loose. That's why he didn't tell him in advance. But there's no reason the judge could not have said, knowing that everyone's there at 9 to start at 9, said, hey, we're not starting yet. We're going to have a meeting. The state has requested this meeting under rule such and such and such. We're going to have this meeting. And at the conclusion, we'll resume court.
Communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate.
I'm gonna tell you, I'm gonna fast forward this. I'm gonna tell you right now, she's speaking gobbledygook, and it's not helpful or useful.
To appropriate remedies for circumstances such as
and
this.
honestly, if I were her, I would just shut the hell up. See, in court, especially criminal court, the person who's doing the most talking when there's a hearing is losing. She literally should have said, we agree with Your Honor's decision, and sat TF down. That's what I would. Thank you, Your Honor. Thank you. That's how you know you win. Thank you.
Apart from what the court has already said, because
and
it's
also,
grave enough.
The reason you don't do a bunch of talking when you're winning,
when information
you can
is
talk yourself out of a win.
Court's chambers.
Kind of like if you dated somebody, sometimes you about to give them some, then they say something so stupid.
And
like if you dating somebody and you were about to give them something, then they say something so stupid. It's like, man, you just talked yourself out of some butt. Now I'm not giving you anything because you didn't piss me off. So that's why when you're winning, shut up. Shut up. All right, now here we go.
Whatever it is that they are trying to argue based on information
hit that like button and
illegally obtained
from
the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams. He has two attorneys.
Okay, yeah, he does.
Now here's the thing. This is the guy where the judge was trying to tell him, hey, I'm taking Brian still to jail. Sir, whoever you are, go ahead. I want you got to defend him for the rest of the day without the assistance of Brian, because Brian's going to be in lockup back in the back. This man is like, ho, not me. No, sir, no way. And that's in part because if this man does this without being completely and totally and 1,000% prepared, he has opened himself out for a malpractice lawsuit. It don't matter that the judge made you do it. It is malpractice to not do what he's doing now. Watch.
But the court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts.
What he's saying is basically, I'm just as guilty as Brian. I found this information out, and so did Brian. It's kind of like sometimes, like I got into it with a friend, and sometimes a friend would pick on, because they know I'm crazy. They'll pick on my other friend and say like, well, both of y'all knew my man was cheating on me and y'all didn't tell me. But they'll be mad at my other homegirl and not be mad at me, because they know if they mad at me, I'm going to tell them about their stuff. That's like what we're dealing with right here. He's saying, I know what he knows too. And it's very interesting that you want to lock up the lead attorney on this case. Shout out to the lead attorney in his channel. It's just fantastic. But he's saying you want to lock up the lead attorney here, Brian Steele, and tell me that although I have committed the same offense, that I have to stay and I have to defend this man.
The continuation of this trial, I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
You cannot.
All right,
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but
so the judge is saying, I'm not holding you in contempt because I did not ask you who told you, and therefore you didn't violate whatever imaginary rule he's referring to. By not telling me the information. But the truth of the matter is, if he really cared about the information, and this wasn't just a big hubris, a big ploy to just flaunt his power, he would have asked the both of them. If he cared that much about who it was that said, he would have asked everybody. He would have said, anybody in this courtroom know who told down? Anybody? But that's not what this is about.
I'll leave it at that. Okay. What is it, Mr. Sharp?
They done took that man away.
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell,
These are the
I am
other
gonna be moving
defendants'
for a
attorneys. They're
mistrial.
all moving for mistrials too. So I'm gonna fast forward through that a bit because it's the same
Has
ground.
been sworn in. And
Because you have to put it on the record. Nothing can be assumed. If you don't make an objection now, you cannot on appeal use that as grounds for overturning a ruling.
thank you.
I've noted your motion for mistrial. It's denied. Okay, I'll, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right,
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Marquez Huey.
okay,
We are also adopting
Yep.
all the arguments that have been made.
all right, sir.
Still by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also we were here for the time. And when the court did come out, we were not made aware that there had even been an explanation that was happening.
We'll fast forward through him. He's basically saying we want to.
Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point we need to get started, resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not calling nothing.
Watch this.
I'm not going to participate in the trial without stealing.
You don't have that luxury at this point in time, sir. You don't. You don't have that.
This is him saying, this is the co-counsel saying basically, Your Honor, I'm not prepared to take over in the place of Brian. Like, sir, are you crazy?
You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time.
You made something out of nothing. Listen, because you won't tell us what the nothing is. How do we know it's nothing? You, Your Honor, cannot even point to the law that permits you to do this. So you don't get to say it's nothing when you won't even tell us what y'all talked about. Tell us what you talked about so we can decide if it's nothing. How about that?
Time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to.
He says, respectfully, I will not, as in he's not going to take over the representation of Young Thug.
Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly.
Extort the court.
Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is
look at Young Thug's face. Young Thug is like, yeah, I had the right one
this morning. That
If there's any accuracy to some of the information that we.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that.
Pause. He's saying it's a violation of the sacrosanctness of the court's chambers. In other words, the court's chambers are so important. They are so critical to a trial and to the conducting of a trial, that someone telling what happened within that room is such a huge violation. Well, if it's so sacrosanct, why didn't you invite the defendants? If it's so sacrosanct, if it's so important, if it's so significant, anything significant, the defendant has a right to know. It's called Brady. That's why there are all these cases that get overturned years and years later, because they find that the prosecution withheld evidence or information from the other side. Here, what Glanville has withheld from Young Thug's lawyers is the fact that Glanville told this man who said, I'm not going to testify, told this man, if you don't, I'm not just going to lock you up for 2 years like you thought. I will lock you up indefinitely. If that is not valuable information for the defense, hell, I don't know what is. Especially because Lil Woody, and it's Woody, not Woody, is the star witness for the prosecution. If you got to threaten the star witness with indefinite incarceration, baby, you ain't got no case.
You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened.
Hey, he's saying that's not what happened. We don't know what happened because you didn't invite them to come. We don't know what happened. Now, the judge did say that it was recorded and it was on the record, but currently the issue is they have demanded a copy of the transcript, but we're going to see whether or not the judge redacts, which we think he's going to do, redacts sections of the testimony. And oh boy, if he does.
That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been.
This is Young Thug's co-counsel.
You made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Bless his little heart. He said, I'm taking my jacket off for this now.
Your Honor, would the court afford me one moment to consult with counsel regarding the appropriate agreement in this type of
Okay.
No, this is the state saying, give us a second to talk amongst ourselves. This is where they come together and they realize, oh, hell no. If we do this, it's a guaranteed mistrial. Watch what she says. When
yes, sir.
She realizes that it is completely unlawful and
Williams
illegal
does not wish to go forward without me being here.
and reversible error to continue the trial without Brian. Here's Brian's testimony on that for the record.
You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present. And I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir.
All right, it cuts it off beforehand, but the next thing that happened was the state comes back and says, it's okay, Your Honor. We ask that you allow Brian. So they do bring Brian back and then they proceed. And at the end of the day is when they try to lock Brian back up. But I want to answer this. Somebody says, is the judge corrupt, incompetent, or both? He certainly doesn't know the law. Here's the thing. This is why you got to really watch state court judges. Because state court judges are elected in most states. In most states, they're all elected. They're not even appointed. They're only appointed in situations where an opening occurs, like how Judge Christina was removed from the bench. She's going to be replaced by an appointment by the governor. Because state court judges are elected, a lot of times they don't know what they're doing. I won't say they don't know what they're doing. I say they follow the law in a much more fluid way. And because of how elections work, when they are doing their job, they are forced to always consider in the back of their mind the fact that they got to run for re-election every 4 years or 6 years or whatever each state says. So they can't just do what's right by the law. They are forced to do what's right according to the court of public opinion. And with Judge Glanville, he took this bench during a time, and this case came about, this YSL case came about during a time when Atlanta had crazy crime. Remember, there were those knocks, knocking and burglaries that like even so many of the women on Real Housewives of Atlanta suffered, Marlo and Candy, etc. The crime was rampant. And it was claimed that the crime was caused by RICO type organizations like this one. So he had the potential to look like a hero by being the judge that oversaw the RICO case that brings safety back to Atlanta. Compare that to federal judges. Many people forget federal judges serve for life, not just the Supreme Court. Most people know Supreme Court is for life, but even the lowest level federal court judge, which is your district court judge, is a lifetime appointment. That is also why when people out here that say elections don't matter, I call BS. And I say that's not true because the next president, and every president actually, has the ability to do these lifetime appointments. And these are the lifetime appointments that steal our rights for things like access to health care, access to, pro-choice, pro-life, those things. And Trump has said if he wins, that his intention is to put federal judges in place who are 25 years old. That's going to be 3 to 4 generations, y'all. 3 to 4 generations. And we know that they're conservative. And we know that they believe that the police can beat your bottom and have no ramifications. So I say that to say part of the reason why it's a bit of a kangaroo court is because you have to always remember state court judges have to get reelected, and they want to do what looks the best in the court of public opinion, versus federal judges who, once they're on that bench for life until they decide to retire. So they don't care what you think. They don't care about what looks good. They focus more so on following the law or following the morality and the rules of whatever president put them in office, because you're stuck with them. And at this point in life, it is probably time that we change it, and that federal judges should not be appointed for life. But it's tricky because you want there to be an incentive to do what's right and not have to deal so much with the court of public opinion. So, perhaps instead of a lifetime appointment, it should be decades long. It varies. But it says, in your opinion, can the judge be sanctioned for his behavior? Can, should, and will. Whether he gets sanctioned now, while he's still presiding over the case, or whether it doesn't happen until the case is over, yes, he can. If you go back and you watch, I break down one of the rules that they use to take Judge Christina off the bench. And the gist of it is ex parte communications, which is what Judge Glanville did under CJC, which is a Georgia rule for judges, Rule 1.2a. Specifically, what Judge Glanville did is inappropriate, and I'm quoting the language that was used in Judge Christina's case. It was inappropriate ex parte communications because, quote, it diminishes the public confidence. I'm going to share this one. Quote, it diminishes the public confidence in the independence, integrity, and impartiality of the judiciary, and it weakens the public's perception that the judge has afforded all the parties the same right to be heard. That's the issue. If in Judge Christina's case, it was a much more minor and ministerial issue. It was a probate matter involving a hearing with a widow versus the daughter of the decedent. Here, we're talking about a man's life who is facing life. So absolutely, I believe that this judge here should be sanctioned at a minimum for what he's done. And the hope is that this can be reviewed prior to the end of the case. It really seems that the best and the wisest decision of Judge Glanville would be to recuse himself. But apparently his ego is too large and he won't. So it says, we need to get you on all Black radios to talk about the importance of voting in local elections. I would love to. I absolutely would love to, because if nothing else, I understand that sometimes you have to pick between two bad choices, but you got to think about the generations and the fact that the court is only going to get more conservative. Literally, 2 of the justices, Clarence Thomas and Alito, have said if Trump gets reelected, they are going to retire so that he can fill it with other conservative judges. They're just waiting. So it really, really does matter. Hit that like button if you hadn't already. Also hit that subscribe button. My goal is by the end of the month, by the end of July, see if I can get up to 25,000 subscribers, y'all. Christina Peterson, it says, Christina Peterson has to watch the cell phone. You have to watch a cell phone video before. You see her just standing there and some guy is running down a woman throwing punches. Absolutely. I agree. And when I talked about it earlier in this video, what I talked about is the fact that at that point, it made sense that she's trying to pull that guy off of her. But at the point when she's shoving the police officer and yelling at the security guard, it's now been under control. And more than that, in the Big Tigger video that we played earlier in this live, you hear her say, I didn't know those people. I'd never met that woman before, but I decided that man had no business putting his hands on her. He's security. That's literally what he's supposed to do. And if the concern is separating her from the man who was hitting her, then that guy was doing the right thing. Because you're saying you were trying to help. So it doesn't make sense. Her story doesn't make sense because the goal is to get that woman to safety. Nobody denies that. So why tell the security guard to stop what he's doing? But she literally, her words were, I was telling him to let that girl go and he wasn't listening to me. He wasn't, girl, who is you? First of all, nobody knew that we've got a judge in the nightclub tonight. Nobody knew that the judge was in the premises. And even then, you're not even a criminal judge, sweetie. You're a judge over wills and paperwork. You do the paperwork. And that type of judge is very valuable. But the point is, it doesn't change the fact that what you were charged with is what you need to address. And either say, I'm sorry, there was a misunderstanding. No point does she say, I'm sorry, there's a misunderstanding. What she says instead is that this in the Big Tigger video, it was fantastic. Roll it back, check it out, because the gist of what she says is that this police officer, he attacked me and he hit that lady. So now everybody hit the lady and you were saving her from the police? I'm guessing. But specifically, she says the police officer hit that lady. Never happened. Did not happen at all. And then she goes on to say, and then that the police were trying to cover up their behavior by locking her in the back of the police car for 7 hours. When the truth is, she was in the back of the police car for 7 hours because she refused to give the police her identity. She even insisted that they just run her fingerprints. They did that in the first hour. Her fingerprints didn't come through because she's not a criminal and had never been fingerprinted before. And she still insisted for the next 5 hours to not give her name and instead told them to Google her. So we've got issues with the truth. And I think ultimately the bar is going to look at all this behavior and probably give her a slap on the wrist and tell her, you need to go sit down and think about what you've done because you're crazy, or at least you're acting that way. It says Peterson was mistook the off-duty officer working security for the man that was assaulting the woman. No, she didn't. No, that's two. Let's be clear. There's two different people. There was a security guard and a clothed police officer. We know that he was in uniform because he's in the footage. He's in various footage because the body cam isn't just the police officer who was there. There were other officers throughout the night who were trying to get her identity. So in some of the shots, the footage comes from the body cam of some of the other officers that were brought in to figure out her identity when she wouldn't tell people. So no, she did not mistake and he was not off duty in that he was doing what's called an approved additional job. So it's important to know that distinction. Off duty generally means not in uniform. This guy was in uniform, but you were right. He was not patrolling. So that part is correct. He wasn't patrolling. He was on duty. But she was yelling at the security guard who was wearing a shirt that said security and instructing the security guard to release the woman as the police officer is there on site. Hey, Tia, so good to see you. Yeah, he clearly had a police officer uniform on. If you look at the footage, which I rolled back, I played for them earlier. He's got a uniform on, and the whole time you're unless you're an undercover officer, you're not to be driving a police car without your uniform on. But that is what she says. So just Coco JB, thank you for the comment. I just wanted to have the opportunity just to clarify that there was two there in the footage. You'll see there was a security guard that's like standing like right here, and the security guard is who was able to grab the woman away from the man first. And then while the security guard has him, she goes up to the security guard and says, "Let that woman go." So she doesn't think that the security guard is the man that was hitting her. That man looks distinctly different and is much larger, or as large, but looks, because I think the security guard had like locks and stuff. Here we go. It says she was charged with disorderly, not battery. The police story she says. So she says that they changed up. Here's why they changed. Because she pissed him off for 7 hours. So the first guy who was arresting her was just going to charge her with disorderly conduct. But what happens was she continued to violate the law when she refused to give her identity. Because under Georgia law, you must provide ID to an officer either if you are driving a car or once an officer has probable cause to believe that you've committed a crime. Here, there was probable cause for the officer to believe she committed the crime of hitting him when she pushed him or whatever. And therefore, at first, it was just going to be the disorderly conduct. However, because she refused for 7 hours to disclose who she was, which actually could have been an additional offense of failure to ID, they added the second offense. So it was a battery of an officer, but they also added the felony obstruction to an officer. Obstruction includes things like refusing to identify yourself, but also hitting the officer. And the thing was, if she would have just given her name, she would have been in and out probably with the disorderly. So that was her choice. Yeah, the security guard did have on a shirt that said security. Somebody said her friend said her name more than once in some of the footage. I saw that too. But what you have to understand is that officer probably wasn't remembering that at the time. And what I heard is her friend said her first name. I didn't hear the second name. But nonetheless, when the officer finally gets everything, when all of this is happening, so the officer is trying to get her in the car and the friend is yelling and she's saying something else and the officer is trying to get her under control in the back seat. At that point, the friend is like, she's Judge Christina or whatever it is. And she says something to the friend of, don't tell him. Don't say anything. Don't tell him. She literally is like, don't tell him who I am. Either way, the fact that the friend did say it, once the officer is literally pen and pad out, looking you in your eyeballs and saying, what's your name? So he can now write it down. He can't be expected to remember what happened 5 minutes in and go, I know I can't. Had no authority to be ordering anyone to do anything. Yeah, that was kind of weird. So APD has nothing in place for Jane or John Doe. That's great that you asked that. Actually, at one point of the video, the two officers asked themselves that. One officer says to the arresting officer, I think the arresting officer, one officer says, can we do Jane Doe? And the arresting officer says, I don't think we can do that anymore. And apparently they couldn't because, they tried. They even, like I said, ran her fingerprints. Either way, the officers are not responsible for finding a solution for a problem Judge Christina created. And Judge Christina doesn't get to create the problem of being in the back of the car for 7 hours, wasting police resources, and then claiming that the whole reason it took 7 hours was due to some form of corruption against the officers. I believe the bar, when they review this whole thing, the footage, all of those things, they're going to look at things like that. And the fact that she literally went to the media and placed this lie on the police and said, hey, you are embarrassing. Not only did you embarrass the judiciary, and that part's been resolved, but you're embarrassing attorneys because you are putting disrepute on attorneys because now you sit here and boldface lied. Somebody said, did you see the hour-long video where they're getting out the patrol car and getting booked? We did. We played that earlier today. She was nasty when she walked in the station, still yanking her cuffs. Yeah. Oh, that was the other thing. She accused the police of part of their corruption and against her was that they hurt her wrists with the handcuffs. Hold on. That was such a great one. I was like, this is the dumbest thing I've seen in a really long time. This is pretty stupid, guys. Here we go. Here it was, 14. Here, I got it. It was, 1442. Let's share this one. I'm going to play it for you. This is a clip. This is a clip from her interview with Big.
Being placed on you that this is not conduct becoming of a judge.
Mm-hmm. Well, I understand that, again, you're looking at the effects. You're not really understanding the cause. In that instance, if you've been violated, I don't know if you all have been violated by an officer. I don't know how you have been, in my opinion, honestly, I can't go too much into it, but what I think the officer was doing was trying to cover up his improper acts. He rode around with me for 7 hours. He arrested me at 3 o'clock and I didn't get to the jail until almost 11.
Wait, so, okay, between that time, what were y'all doing? What was he doing?
He was antagonizing me. He was, remember,
for 7 hours?
Listen, the cuffs were so tight. I had bruises on my arms. I mean, listen, he was stopping his car and getting out, and he was nervous. He was visibly nervous, and he was making phone calls, private phone calls.
Wait a minute. So for several different hours, you're saying 7 hours. So from what time to what time?
3 until after 10. That's when I got to the jail. And I'm going to say that I believe he was trying to cover his tracks. He had violated me, and then when he found out, and he knew on scene that I was a judge because once he put me in cuffs, people were like, "That's a judge." So then I think he had to come up with that whatever story whatever they ran on the news. So it was inappropriate. I asked him I said, am I under arrest? If I'm under arrest, I would like an attorney before I give you any other information, because if somebody ever lies on you, you need an attorney.
Listen, that does not apply to your name. You absolutely are entitled to an attorney once you're under arrest, but it doesn't apply to your name. Because what do you say on the phone when you call the attorney? When the police department contacts the attorney, and the attorney literally, she done did it now. She done pissed me off now. That just dawned on me. When the police department calls and says, all right, we need an attorney here, this person has asked for an attorney. The first thing we do as an attorney, before we say, yes, I can represent them, we have to run something that's called a conflicts check. A conflicts check means I have to make sure there's no reason that I can't represent this person as a result of any person that I've ever represented. So for example, if someone has a co-defendant, you got to do a conflict check. You can't represent that person and their co-defendant. You even need to do a search. If they have a co-defendant, you need to make sure you've never previously represented that co-defendant. My point is, because she refused to give her name, even if she wanted a lawyer, they would have difficulty getting her a lawyer, because the lawyer would be like, well, who am I representing? He'd be like, I don't know. Well, the lawyer would be like, well, I can't represent them if I don't know who they are, because I must do a conflicts check. Goofy broad.
We don't need to even have any more conversation. So that's what I did. I said, I don't want to give you anything. And moreover, I would have my license if you didn't knock me out and my purse got taken. You understand? You didn't even let me get my belongings.
Girl, they didn't let you get your wig.
Not at all.
They got it out there with the braids. Oh my God.
All right, there we go. So my point is the part of this clip that I found super interesting was the fact that, this is where she basically has victimized herself and is alleging that all of this was a ploy by the police to cover up what they said. Now, to be clear, the press release said one thing, and in the video you see first the officer says disorderly conduct, and then it changes. This is important to understand with officers. So officers, it's not up to the officer ultimately what you're charged with. It's up to the district attorney's office. Dun, dun, dun. That's why we as attorneys tell y'all, don't be talking to the cops. They don't have the authority to give you immunity. They don't have the authority to give you what you want. You want to talk to the district attorney's office. And what happened was the district attorney's office probably looked over the evidence, looked over the body cam, saw how she behaved, and said, oh no, we sick of her. We're going to charge her with this. So I say that to say the patrol cop doesn't have the final say over what you're charged with. It's the district attorney's office. And that's how come you will see cases all the time where someone is initially charged with one thing and it gets upcharged to something more severe later. It's because the district attorney's office has an obligation to not go solely by what the police say. They have to do their own review, and based on their review as an attorney, determine what is the appropriate charge. So that's what happened here. And so she asked for a lawyer. Doesn't she have a right to remain silent after that? She sure does. She chose not to. She chose to cuss him out, call him the N-word, and do everything else. She's so, oh goodness. Somebody said she wanted her attorney to do a voice recognition. I don't know. But Coco JB said both of these cases, Peterson and Young Thug, are a masterclass for citizens across the nation of what not to do. Yeah. Somebody said, how many people use fake names at the club? Oh, all the time. That's very true. And what you don't ever want to do, I would say you give no name before you give a fake name. If you know, for example, if you know that if you're a passenger in a car, and the police walk up to the car, if you are a passenger, you have no obligation to give the police your identity. But what will get you messed up? So let's say I've known people who thought they had a warrant or knew they had a warrant. They were not the driver, but they were passenger. You simply say, not disclosing. There's nothing the cop can do. If you've not committed a crime and you've not given them any probable cause to believe that you have. Now, it's different if you're in a car that smells like weed, because that creates probable cause to believe that you have smoked weed, which would be a problem. But if you've not done anything like that, if you're simply a passenger, you don't have to give them no ID, and it's better to give them no ID and no say. Now, and sometimes police officers will try and trick you. What they'll say is, oh, well, if you don't tell me, I'm gonna have to give you a failure to ID. It's like, what is your probable cause? That's what you ask. You say, I'm not the driver. What is your probable cause, and what is the crime that you believe I've committed. And they're going to have, it's nothing. So you don't have to tell them nothing. And that's what you do if you think you got a warrant. Don't sit up there and lie. And definitely don't say anything like, well, I don't want to tell you because I don't know what you're going to just, I'm not telling you. You ain't going to tell them. Thank you. Oh, Tamika Monet. Love your commentary. My new favorite channel. All right, guys. So this was great. I'm going to let you guys go. Hit that like button when you're out. Share this with a friend. Please share this to your Facebook. Share this to your social media. I'm definitely trying to grow this channel. I'm working on definitely doing my little story time. Y'all ask for story time so we can get that. Oh, Simone B, great comment. Obstruction can occur later if they find some. That's absolutely. So here she, in the car, she wasn't initially told about the obstruction. I believe that the obstruction charge came here after for 7 hours, she's over here playing reindeer games with these cops by refusing to give her identity. That literally is obstructive of the process of trying to process you. And imagine how much money and resources. At points, there was 2 different police officers trying to talk to her and simply say, ma'am, please give us your name. All the while, she's like, Google me. How do we Google you, ma'am? You want us to do like catfish, take a little picture of you and then do the, like, ain't nobody playing these games with you. And I don't think the bar is going to be playing games with her either. So we'll keep tabs on this. We'll keep watching. Thanks for tuning in. As well, if there's any other topics you want me to cover, please mention them below so I can do a deep dive on those. Tia B, I watched the Ready to Love episode you posted. She said she's a bully. So Christina was on Ready to Love season 2. I was on Ready to Love season 3. She was on Ready to Love season 2, the first episode. I did post that on my YouTube page, so you could check that out and you can see that. But yeah, I am working on finishing up my, what do I have for y'all? My story time. I'm gonna have that released. I also rolled out my membership. So I've got some new members. I'm excited about that. Members are gonna get the story times first. They're fun. God, I have so many ridiculous stories about my life / legal. But also I'm going to be rolling out. I do once a month. I do a joint podcast episode, YouTube episode with the Poor Horsemen. Poor as in pouring a drink. And I love those. We call it CYA, but it stands for Call Your Attorney. You got to check that one out tomorrow. It's super fun. It's myself and another lawyer. And then it's like 2 normal people, right? We answer their questions and we talk about trending legal topics. I do my best to break them down in a fun, funny, just like regular legal way. So thank you, Legal Ray. I love your channel. I hope to grow my channel like yours. Well, maybe we can collaborate. So if you hit my Instagram, that's probably like one of the best ways, or email to contact me. All right, guys, I'm hungry. So I'll talk to you later. Hope y'all have a great day. Bye, y'all.